So, Lori, I'm just going to wait for the camera to come in front of you. I see that Rachel's coming on right now. So the video is showing the participant or interviewee as Rachel Baird, but in fact that's going to be Lori Longhi. So we're here in the law office of Attorney Rachel Baird in Rocky Hill, Connecticut, and with me to commence this interview is Attorney Rachel Baird and Lori Longhi. Ms. Longhi is going to participate in the interview. And her name just changed from Rachel to Lori. Okay, great. So here we go. So, Lori, thank you for joining us today. Thank you for participating in this interview and providing us with information. And I can see a lot of documentation in front of me that you plan to hand in regarding our review.
I think we should switch because you just looked at the last time we had Tom up against this wall, and I think it looks so much better here.
All right, we're gonna stop.
You think it's fine?
Yeah, she looks great.
Okay.
She looks great. Doesn't matter.
So I don't want you to be washed out.
Okay. So we record, as I think you know, we record these interviews. Could you just please confirm that you understand we're gonna record this and it's acceptable to you? Okay, thank you. So this is not a deposition, but I'll kind of state some of the rules I normally do in a deposition in order to have a clean, although we do a video here, but we're going to try to potentially do some transcripts for our assistants here. So if you're going to give an answer, I'd appreciate it if you could do so orally. Head nods like you just did, and making hand signals doesn't pick up on a transcript. And if you don't understand a question, please let me know. I could try to rephrase it. You don't have to guess at things. You don't know something, you don't know, that's fine. If you want to take a break at any point, that's okay. I know you have counsel here. If you want to take a break and speak to counsel, that's fine too. The only thing I'd ask is if I asked you a question, and you decide you want to take a break, just if you can answer the question before we take a break, that'd be great. Do you have any questions for me process-wise before we get started?
No. And I understand what you said.
Great, thank you.
There.
So I assume you were a resident of the town of Enfield?
Yeah.
How long have you been a resident there?
My whole life.
And so how's that, 27, 28 years? How long?
60 years.
How long?
60.
Wow, you look at some 60 years. So you've been a resident of Enfield for approximately 60 years.
Yeah.
And I think you told me earlier when we were chatting that you're married and you have 3 children.
Yes.
I see that you have a resume in front of you.
Yes.
That's actually helpful. Can I see it, please?
Sure.
Okay.
I don't know.
No, that's
okay.
fine.
That's fine.
They have numbers at the bottom.
Oh, okay.
I did.
Oh, you did that. Okay, that's actually helpful.
Yeah.
So, so there's a resume here, which is, and can I have some clips if you don't mind?
Like the little ones, yeah.
Or anything, you know, regular clip.
I don't need, I'm going to keep them the way I have them. It's fine.
That's fine. I'll clip them as we go. So, see that you have an associate's degree in merchandising and retail management,
Yeah,
and that was from Bay Bath College,
yeah,
and that's in Long Meadow, Mass.
yeah.
It's an interesting degree. My family was in the men's clothing business for most of my life. Retail management is not easy. Where did you go to high school before that?
Enfield High School.
Okay. And I see here that you are a certified general appraiser in the state of Connecticut.
Yes.
So it looks like you got your associate's degree. When was that?
1982, I think, is when I graduated college.
Okay. And And so, as far as your employment background, when you finished college, what did you do?
I worked for specialty retailing in Enfield, Connecticut.
And what type of company is that?
It was a clothing company. It used to be called Casual Corner,
Okay.
and they had their corporate offices in Enfield. So when I graduated as a retail management, I worked for them for a few years.
There. In my recollection, isn't there another? Are they still there? Is there a big?
They're still there. Brooks Brothers is their other subsidiary.
So that was the Italian guy, Claudio, who bought him, right?
Yes,
Who, if my recollection is correct, was the Bali shoes,
yes, I believe that's right.
and he bought Southwick, and he bought Brooks Brothers, and then they had the
Yeah, and then Casual Corner ended up closing, and but he still has the building is still there and it's still operating as Brooks Brothers.
yeah, and I think they produce a lot of the goods out of Lowell, Mass. In the Southwick. I'm not wearing one of their suits
Yeah.
in the Southwick factory, if I remember correctly. But yeah, it was all out of Enfield, which is
Yeah.
interesting. This Italian clothing conglomerate is headquartered in Enfield, Connecticut. So that's more interesting than talking about this other stuff, but
Mhm.
we do that later. So after you left that company, where did you go?
I actually
Or did you
worked-
take some time off? What did you do?
I actually worked for my father in the construction company. He was building, I want to think like 52 houses at the time.
Oh.
So he was looking for somebody to run his office. And it was just getting too much paperwork, so I went over there for a while. And then shortly after that, I then opened up my own business, my own landscape business.
I saw in your resume, it says 1997 to 2009, new home construction. And then J&L Builders and Longhi Landscape Construction, right?
Yeah, Longhi Landscape. So my company, I had my own company, and then I met my husband. He had a landscape company. And so instead of us running two separate companies, his had been in business longer. So we kind of merged the two businesses and opened in Connecticut. He was out of Massachusetts.
And the title is Longhi Landscape Construction and Farm. So what's the farm part of it?
The farm is greenhouse. It's a greenhouse operation.
And then I see from that 2019 to present, you've been a real estate agent,
Yes.
and that's with is that with CT Hometown Realty?
Yes, but they recently merged to a national company, so now we're called Realty One Group.
And is that located in Enfield?
Yes, it's the same company, and we still have all of our signs, and we're in the process of a kind of a transition of changing from Connecticut Hometown to Realty One Group. But our licenses are still both.
So, and have you been a general real estate appraiser since 1999?
I was certified general. I got later, I first was a residential appraiser, and then I got my certified general appraiser's license. I don't have the exact dates.
I'm just reading.
Oh,
from your
yeah,
resume.
yeah, if it was a certified general, I was part-time at Farm Credit. But my first license was a residential license, and then I became a certified general license because you had to have work experience.
So you started off doing appraisal work in 1999, and then
Yes.
as of 2006, you received your general appraiser license with the
Yeah.
state of Connecticut. Is
I
that
don't
correct?
know the exact date I received the certified general. I'd have to look at the licensing, but I was like a residential appraiser for like, let's say 3 years. Then I became a certified general.
I was just going off your resume.
Yeah.
Your resume says 2006.
Oh,
Your resume says you've been a
okay, so yes, that's probably,
certified. I'll
Yeah.
take your word for it. That
Yeah.
you've been a certified general appraiser since
Yeah.
2006, but that you did some that you did appraisal work prior to that.
Yeah, so I'm like.
Starting in
99.
1999. So it sounds like from 99 to 2006, you were doing the work that led up to you getting your license. I think you get like a provisional.
At first I was provisional, then I got my residential license, then I got my commercial license.
Oh, so you have residential and commercial.
Yes,
So you're licensed in Connecticut as a residential appraiser as well as a commercial.
yes, but what happens is once the residential is a lower license.
Yeah, and then when you become the general
General,
35
it
trumps
goes
it.
away.
Okay. You still do appraisal work,
Yes,
commercial and residential?
yes.
Okay, you do a lot of papers, so that you're.
I wanted to explain about my expertise in agricultural appraisals.
Okay, good. So I see here, why don't I go through what you've given me?
Okay,
And then, because, so for example, I see here, there's a document, it says, it's January 18, 2023. It's an appraisal bid request for farmland from the Connecticut Department of Agriculture. It's addressed to you. It's a big stamped document LL 005. What would you like to tell me about this?
well, I just wanted to mention that my expertise is in agricultural appraisals, and I did do agricultural appraisals for 22 years. And I specialized in development rights restricted farms. And so I put a deed in there because I wasn't sure if you would be familiar with the development right restricted farm. But when people sell off their development rights to the state of Connecticut or the USDA or the federal government, they have to get an appraisal done. And they, the farms are then restricted to agriculture in perpetuity. So the deed restriction makes it unable for them to do anything else other than farming.
That's interesting. So it's basically analogous to, for example, if somebody has a affordable housing project approved, an eighth Connecticut General Statute 8-30G application, it gets approved, and they do a deed restriction on the property so that 30% of the units have to be deed restricted affordable for
Right.
a long period of time, or you get a affordable housing project has to be that gets, because of CHAFA or FHA, gets deed restricted for some period of time. Then that obviously affects the value because the market rate is controlled essentially by what the limitations are and what you can charge.
Right.
Okay, so just so I mark this, because this is the quickest way to do it for my purposes later on. So this deed that you provided me, this deed is an example of a what?
Is a development right restricted.
Okay, just go a little
deed.
slower as I'm writing it down.
Okay.
It is an example of a development.
Right restricted deed. And this particular one.
Well, hey, just before you get into the particular one, so a development right restricted deed, what is it? How would you define it or describe it in
okay.
general?
So within these deeds, the state of Connecticut, and this particular one, because it's conveyanced the state of Connecticut, there is no ability to build a house. There's no residential on it. It only can be used for agriculture. And it's very specific to what you can and can't do on the land.
Got it.
Like you can't mine, you can't get rid of the soils. And so they're very encompassing. There's only about, I would say, under 10 appraisers in the state of Connecticut that can appraise development rate restricted farms. They're called Yellow Book. And you have to have a special federal class to do Yellow Book appraisals.
So for example, would an example of a yellow book appraisal be for example, so that you have a before and after value of a property if there's an eminent domain
Yes.
taking, is that correct?
Mhm.
So that's an example of a yellow book
Yeah.
appraisal.
And they're also used for development rights.
So it is another example of a yellow book appraisal where CLMP, some company needs to get an easement for some purpose over someone's property. Or for a better example would be maybe DOT has to do a project. DOT needs an easement, which would be part of it would be a temporary easement, part of it would be a permanent. So you need valuations of the temporary and the permanent, and that would be a yellow, what you would describe as a yellow book
Yeah,
appraisal, right?
it depends, yes, if they requested a yellow book. I don't know if the
DOT usually does yellow books,
Okay.
yeah. Okay, so are there any of these were there any properties that that you believe the assessor in Enfield improperly valued that happened to have a development right restricted deed?
Yes.
Okay, and what were some of those properties?
I
Did you,
have
are they,
one is Appeal 300. So I'm gonna go to that one.
where is it on in the pile that I have?
Let's see. It's the first one.
On the bait stamps, what is it?
Oh, I'm sorry. LL 063. Oh, wait a minute. This has got the wrong. Okay. Oh, no, wait a minute. It's LL 021, I think.
LL 021 is an excerpt.
Okay. 20. And then 21, 22, wait a minute. I was giving you actually the document, so it's LL 026, but you'll need the previous pages. So I'll explain it.
LL 26 is
Appeal 300.
and this appeal 300, what is it? What number does it end on?
41.
And with regard to this one, do you believe that the assessor made a mistake in the way he valued it?
Yes.
So this is an example of a deed of a development
Right, restricted.
right restricted property.
Mhm.
Which the assessor, according to you, improperly valued.
Yes. Actually, it was grossly excessive. And I'll show you why.
All right, so improperly valued.
Okay.
Okay, so okay.
So the value, it's probably easier if I go through it and then I can explain it.
Sure.
Okay. So it's 29 acres of development right restricted land that can only be used for farms.
By the way, this is appeal number 300, which just so for our record is bait stamp the bait stamp documents LL 026 to LL 041. You know what? I wasn't going to do any exhibits in this because I haven't done it in any single interview, but you seem to have by far the most stuff. And I think your explanations are going to be the most helpful. So if you don't mind, what I'm going to do just for purposes of making this easy for us, I'm just going to put exhibits only for this interview.
Yeah.
Just
Okay.
not nothing formal, but this way we're referring to documents easier. So should we go with numbers, Rachel, or letters?
Why don't we go letters because we have numbers at the bottom of the page?
That's what I thought. Okay,
Yeah.
so all right. So the first one, Lori's resume, we're going to put as A.
So let me staple them together as we make some exhibits, Lori, and I'll put tabs on them.
I may regret doing this later, but right now.
I'll do it. I don't
Okay.
want to take the stuff that I didn't talk about.
Oh, yeah, yeah.
Okay.
All right, so that's A, and then B is going to be the letter from the January 18th letter, January 18, 2023 letter from the Connecticut Department of Agriculture to you regarding your appraisal services. That's in the exhibit B.
So A is 001 through 004?
Yeah.
Okay.
And we can go over these later, so we don't.
Why, I told Lori to get mixed up.
That's fine.
so,
B
okay.
is LL 005. And then C is going to be that conveyance C, which is zeros is 6 LL6 to LL6 through LL10.
Yeah, that's gonna be C.
And then D is going to be LL26 through 41.
6 through 41.
All right, so tell me what you'd like to explain about this.
Mhm.
I think I gave him more than 41.
Yeah. So it's 6 through 41 is exhibit
26.
26 through 41 is exhibit D.
So this land was valued from okay. It went from $307,400 to $886,000 to $1,340,000, which roughly on the 29 acres equates to $45,070 an acre for restricted farmland.
How much an acre?
$45,070. So I've been appraising for restricted farmland for 22 years.
I'm sorry, let me just write this. So based on his, so
I am almost thinking, Rachel,
Yeah.
I think it might be easier for him to have what I'm gonna.
I'm fine with it. This is fine so
Okay.
far. So I just really, so
Look it over, and if you're comfortable, you're comfortable.
I was just really,
Your decision, please.
I get it. So the assessor, I'm just writing it down on the documents. I think it's easier. So the assessor valued the land at how much an acre?
$45,070.
$70 per acre, which, I mean, quite frankly, to me, for generally for excess, let me ask this. Do you think $45,000 an acre for excess land that's not part of a building lot is within the range of appropriate fair market value in town of Enfield?
No,
Why?
it's only a few from maybe 7,500 an acre tops on excess land. This is like more than subdivision land in Enfield.
That's, I mean, just to give you an example, in some of the towns I represent in lower, in
Yeah.
the lower part of the state, my recollection is that that excess land that's beyond a building lot. So let's say you have 2 acre building lot and you have 3 acres, so you have 1 acre of excess land that can't be used for a building lot. In Fairfield County.
Oh.
Yeah, I'm just, that's just, I represent some other towns outside of the county, but off the top of my head, I know in Fairfield, like in some towns I represent in Fairfield County, I think it ranges from like 35,000 to 75,000 an acre. That's just my
Yeah,
recollection.
that's nowhere near the values in Enfield.
So he valued it at 45,000,
Yeah.
70 per acre. What do you think it should be for restricted farmland?
Well, I would. So as an appraiser, I don't want to throw a number out because I don't want it to be considered an appraisal. But I will say that out of the 22 years and the database that I have for the entire state of Connecticut, that I do not know of one. And it doesn't matter what town it is, because I have all Fairfield County, I have everything, there's not one that even comes near $45,000 an acre. In the database that I have
In the whole state of
in the
Connecticut?
whole state of Connecticut.
So for example, how about,
Typically, I'll give you typical, because I can give you typical ranges. Typical ranges on a development right restricted farm are maybe $3,000 to $6,000 an acre for their farmland. Sometimes it can go up to $8,000. And if it's an industrial piece, sometimes it can be at maybe tops 11.
so is it fair to say that you think the range is that the overall range is 3,000 to 11,000?
11 would be max. Like, I think I only know 2 sales that were, one was maybe 11 and one was higher than that, but that could have been it was in a town that it might have been an industrial farmland. So, but I have a database of the whole state of
But
Connecticut.
3 to 8 or 3 to 11, it's still substantially less than 45.
Yes,
All right, so let's say the range is 3 to 11.
well, you're saying the range is 3 to 11. I'm thinking the range is more like 3 to maybe 9.
Is okay. So 3K to 9K. All right, and there may be some outliers that are up to 11,000. Is that correct?
Yeah.
So for example, if you have farms like a farm in Easton, think of some towns I represent, Easton, Connecticut. Would it probably be around that range?
Yeah, I have them all for the whole entire state.
Weston, I don't know how many farms are
Yeah,
in
there's
Weston.
like Torrington, Franklin, down at the beach, Donington. We have, wherever there is a development right restricted property, the ranges are, there's so limited sales that we use sales from all over the
Yeah,
state
you would assume.
and
they're-
Massachusetts, because sometimes we're on a border of Connecticut to Mass. So there are restricted farm sales in Mass that we would use.
Is it going to change now that people could, with some properties where somebody could farm marijuana?
I don't think so.
Interesting.
I mean, I haven't seen the change. There have been a few farms that have been up there in value. And you have to figure out what the reasons are. Sometimes it was owner financing, there's are little reasons why
Makes
some of
sense.
these farms.
That would be an
Right.
outlier too, probably, right?
Yeah.
Because how many farms are you gonna have that are gonna
Right.
produce marijuana? It's
Right.
fairly limited, I would assume.
Usually they're not farmers that are doing it.
It's
It's
industrial.
industrial.
Yeah.
So-
It would be done in a greenhouse anyways, probably.
Yeah.
Not in a field.
No,
So
but the problem with the marijuana is it has to be in a protected area. So even greenhouses they need to have security,
of
and
course,
it's a very difficult.
it's not gonna be like the fields of
It's not
Jamaica.
gonna
It's not gonna be like the
it's
fields.
not gonna be in the typical.
It's not gonna be like the fields of Jamaica.
Yeah.
So,
So
I got that.
so where I noticed is, so according to this, it violates the use value on page 7 through 9 on the CAAO handbook. There are legal factors that weren't in consideration of, that's on page 7 and 9.
Violates the use values on CAOO,
Yeah, and those are pages, I gave you the pages, and those are pages LL 21, 22, 23, 24, 25.
LL 21. What?
To 25.
All right, so I'm just gonna mark this as, these are, these are gonna be excerpts
Mhm.
from, is it the CAOO?
Yeah, CAAO
CAAO?
Yeah.
Handbook
handbook.
regarding what?
The rules that weren't followed on this particular appeal.
Rules that were not followed by the assessor for valuation of property subject to appeal number 300, right?
And then I gave a court case because you can't disregard the development rights sold. It violated uniformity, which was also that properties are supposed
Yeah,
to be.
we're gonna, I don't mean to interrupt you, but I don't want to forget what we're doing here. Bait stamp LL 21-24 is the excerpts from the CAAO handbook. I'm gonna mark that as exhibit E. And
Easier to give him
and then
on this one.
you were making reference to a case, correct?
Yes,
Do you have the case?
yes. Nelson,
I don't have it.
I gave it to him.
oh,
You know what,
Okay.
that's fine. All right, so I was wondering why 20 was missing, okay. So I'm gonna change something, hang on, I'm gonna,
I think the first one's the hardest because we have to get our kind of our
that's fine, we're feeling this, out. So,
think.
so exhibit D is the, is appeal 300. I'm gonna change exhibit E. Exhibit E is gonna be LL 20, which is a 1-page with your notes. Actually, you did a good job, you summarized,
Yeah.
you summarized what the basis was for why you think you made a mistake. And then after that, you give me the excerpts from the CAAO handbook. And by the way, a lot of this I'm running through quickly because I get what you're giving me, and then it's helpful to look at it when we're
Yeah.
doing the report. So then that would be exhibit F, and that would be pages 21, LL 21-25. And Rachel, you're welcome to look at what I have here,
Okay,
so that it'll make it quicker.
so he'll just refer to numbers for you for now, because I can't
Okay.
keep up marking the.
That's fine. I'll give you what I have. So we'll
Okay.
take a break in a little while. I'll grab a cup of coffee if anybody else wants one, and then we'll.
Okay. Yeah, I'm actually trying to make it easier for you because,
This is much easier. Quite
Okay.
frankly. So this is like this summary you gave me
yeah,
is absolutely perfect. It's just
because that
makes
way
my
you
life
don't,
easier.
yeah, that's why I was thinking that it was important for you to have my summary.
Makes sense because this way I have the summary, but what you gave me afterwards was the excerpts,
Yep.
and then you're going to give me the court case, right?
Yeah, the court case was in the PA 490 handbook, and it's highlighted the case, but I actually have the case if you need it, but I'm sure as an
Did you
attorney.
date stamp it here or no?
Yes, it's LL 023.
I'm missing that.
Huh.
Well, let me ask you this. Do you want to give me your copy of it? And then what we'll do is you could always make it up.
Yeah,
Before I leave, Rachel can make
It's
another
fine
copy.
because I have another, yeah, anyways.
All right, so it's just one page.
Yeah.
So we'll just,
And we can print out another.
Yeah,
copy.
yeah, I have it.
we're gonna make this exhibit G, and it's just the LL 23. And then G, what else do you have related to this? Do you have anything else referenced in your summary?
The last thing was the audit trail, like in the CAAO handbook, there should be an audit trail to know who made the changes, when the changes were made, and the value previous to each change.
And that would be pages 5 to 46 in the CAAO handbook.
That was page 5-46.
5-46. Do you have a copy of that?
Yeah.
What is it, bait stamp?
LL 25.
This is actually really helpful to do it this way. So I'm missing it.
Yeah. There you go.
Okay.
It might be just because we were going through so much stuff.
Fine, you can make extra copies from here. All right, so bait stamp copy LL 25 is going to be exhibit H. Is there anything else associated with this appeal?
No.
Okay,
So,
so
but I just so that you know,
Mhm.
because I took the actual field cards so that you'll be able to see where I got these values actually correlate to the cards that came to us in the hearing.
let me ask you a question. If we, as we're writing a report, have a question on any of this that you provided us, would you be willing to take a call from us to?
Absolutely.
And Rachel, would we
Oh, that's
call
fine.
her? Do you want us to do it with you on the phone, coordinate it with you, or could we? It'd actually just be Matt Studer if he's doing the report, he has a question about
Yeah.
something.
I tell you what, if you feel like you're uncomfortable or wanna,
Right.
bring me into
I
it,
mean,
but otherwise.
I probably wouldn't call you. I would probably just have Matt do it. So for example, if Matt's doing a report, it says, trying to figure, I think I know what Lori did here,
right,
but I'm confused. I just say, well, just call her.
right.
So I wouldn't be on the, I have no, I wouldn't need to call you, but if my associate is doing this, had a question for you. That's what I would suggest. So
Okay.
we'll get your number afterwards and
Yeah,
um,
because it's so important that I felt like I needed to be in person because the documents were here. So if you said,
what
well,
you're giving me
is-
this many documents.
where is, the 1,307,040 coming from? It's on LL 040, so I can explain anything that is on here and it should be in the documents that I gave you.
I think it'd be more helpful to save time.
Yeah.
If for everybody, if on an example like this, if we're gonna cite it in the report, that Matt call you and say, here's what I think.
The pages.
Here's what I think I understand you're suggesting and why you made a certain decision. Is this correct? And then he could just ask you directly.
Okay.
So he's going to be doing a draft of it. I just think that's the easiest way to do it.
Do you feel like you've covered the subject adequately though for the video? I mean, I hate to play to a video, but
That's fine.
if somebody's watching it, they'll.
Well, the thing about the legal factors that like in it, it's regarding zoning, deed restrictions, easements, deed restrictions in relationship to limitations, terms, and renewals must be considered. So that's why I had all these issues with these development right restricted farms, because as the assessor, you're supposed to be aware of all of these deed restrictions, and that's how you're supposed to be valuing them. And it just, with the value of uniformity, if you are not valuing the deed restrictions uniform with other deed restrictions, and it's a willy-nilly thing, that's where these values got all skewed.
Yeah, I get it. I mean, they're basic, fundamental concepts of valuation. I mean, the concept of uniformity. My recollection is off the top of my head. It may be Connecticut General Statute 12-64. I could be wrong, but there's a rule of uniformity that we have to apply in the state of Connecticut. And I understand the concept that if you have restrictions, whether they be for affordable housing, or whether they be for, in this case, restricting it to an agricultural use, under certain circumstances, they're applicable. I mean, they must be applied. Now, having said that, just to give you an example, in the context of affordable housing, I believe it's actually within Title 8 of the general statutes that provides that that you apply the restrictions that are deed restrictions in affordable housing only when the town has an underlying ordinance that to do so. And that even where there is a restriction on a property, the town is not obligated to apply it for tax purposes. I don't know if that's the case here with. Do you know if that's the case with
I believe
regard?
that's the case because of the fact.
Is that similar here? Here,
Yeah.
is there similarly requiring the general statutes that you have an underlying municipal ordinance that allows you to apply the restriction?
Yes, because in their rule of handbooks and under the farms, they're supposed to be looking at any deed restrictions and easements. So yes,
But I will give an example, for example, with regard to affordable housing, it's an issue that comes up in cases.
but I don't know that component of it. I only know the farm component of it. So I know that it's saying that they're required to look at the deed restrictions on these lands. I think I might have further on in my stuff, I might have where it's listed, but
So
we can circle back to that if you like.
And so, do you know how the assessor got to 45,000 per acre on this property?
I do not.
Did anybody on the BAA ask the assessor? Do you know?
I don't know. I can't answer that question. I do know that this was interior. So let me explain what I, just so you understand the process. So we got to the appeals and there was these little sticky notes on the, all of our appeals. And it said, was forest land, new application for 2021 applied, syllable B, a word I can't read, P-E-N, I think it's 10, but adjoining property, measured acreage via GIS. As a new application due to the owner, it's from forest, did not classify half the property, 14 acres as woodland, only 25% allowed. So every one of these little stickies, I investigated. I did not discard them.
Mhm.
The assessor wrote them down. I looked at them, I read them. And I went in and in cases like this, I actually went like into my mapping software because I have mapping software that also can tell soil types. And I would go through and look, because it said here permanent wetland or wasteland. So typically I know that's like a wetland. And so I would actually go in and measure what the applicant said, what Todd said, and then I would look at it and see who was correct. So on these issues, I actually took the extra time to go into the mapping software, look up the parcel to see what I was dealing with. And I did not once find Todd was correct in any of the reclassifications. It was always the farmer that ended up what they put down that they were doing. Their numbers matched out with my mapping software. And on a lot of the appeals, if you've gone through these appeals, you will see soils maps. Those were my soils maps because I actually put them into the files because I wanted to be able to have somebody know that there was actual real work that was done to investigate this stuff.
That's interesting. What mapping software did you use?
I have a mapping, it's called AgriData, and it's put out by the NRCS and the USDA.
What does NRCS stand for?
The natural resources for the federal government, the natural resource. I don't know what the acronyms are, but
We can figure it out.
yeah. But so it's in some of my paperwork. We'll get to that.
Okay.
So I literally, even if I wanted to think that Todd was wrong, I still investigated every one of those sticky notes. So he was like sending us a message. I read them, I looked at them, and then in the hearings, we would ask the applicants sometimes based upon the sticky notes. And so I felt like we had double and triple the amount of work that was really not necessary for some of this
So
stuff.
is it fair to say that some of the staff notes that were provided to you on these stickies were provided information that was not accurate with regard to the
Yes.
farms?
Mhm.
And the software again that you had was called what?
It's called the AgriData.
And do you know if the assessor has access to the AgriData software system?
I don't think so, because it's a paid subscription, but he could. I don't have that answer. I don't
Do
know.
you think that it would be helpful for the assessor to have the AgriData system available
I don't
to
know.
reference? Well, it was helpful to you, right?
Well, it was helpful to me because I'm an appraiser and I go into the mapping software. So when I'm appraising a property, I have to know what the soils are in order to appraise it properly. So I have to know what's a wetland soil, what's an upland
Sure.
soil, in order to be able to give it the correct value.
But shouldn't the assessor know that information as well when valuing a parcel?
Yes, but the farmer tends to know. A farmer tends to know. Farmers are farming their land based on income. Their yields are tobacco, corn, vegetables, depending on what they're doing. They know what they can farm. When they're cutting down a woodland to add to their farm, they know what type of soils it is because they know what they're growing. That's how they get paid. So really, farmers are pretty astute about farmland. I didn't find any of these that were in conflict with what the farm said, but Todd reclassified them. I don't know what his basis
When you
was.
say you're pointing things, you said it, when any of what?
Any of these application to the assessor for classification of land as farmland.
So
So on this particular one,
Can you give the page? number?
LLO 28, sorry.
So is it fair to say that, for example, on LL 28, that's the application that the property owner provided, correct?
Yes,
So that's Jarmock Farms. It's for property at 45 Charnley
Charnley. Yeah.
Road in Enfield.
Mhm.
And for that property, is your position then belief that the that the information the property owner gave, which was that 14.7 acres was tillable B and 14.7 acres was tillable C, and that 7 acres was woodland, was a correct description of what was there?
Can you repeat that? Because you said two numbers,
Well,
14.7
it
and
looks like
14.22.
no, that's not that's not what I said. It looks like the application provides that it had tillable B as 14.7, tillable C is 14.7, and then it had woodland as 7. Is that correct?
No. And I'll tell you why. The owner's acreage estimate is tillable C 14.7,
Oh, I misread that.
wasteland 14.22, and Todd's acreage assessment is 14.7 on tillable B and 7 acres of woodland in a farm unit.
All right, so
and
just so I make sure we have this, because I misread it before. So
Okay,
the farmer said on the application provided that the tillable C was 14.7 acres.
mhm,
And Todd thought that that same area of 14.7 acres was actually tillable B, correct?
yes,
Why do you think the farmer was correct and the assessor was wrong?
because if they could grow tobacco on that versus corn, that would increase their yield tremendously. And if they could grow tobacco on a field, they would be growing tobacco. They're tobacco farmers, but they also do vegetables.
So is it your position that for this application, which was application number 300, that that the assessor was wrong in classifying the land as tillable B, because if in fact they could have grown tobacco there, this farm, Jarmock Farm, would have in fact done so. Is that your position?
Yes,
And when you had the hearing, did you ask Jarmock's if they're able to grow tobacco?
I didn't do Jarmock's hearing.
Do you-
So it might have been one of the other board members, because we had so many hearings that we each took different people, and then we got the files after the hearings, and we were able to each look through the
Do
files.
you know if anybody verified from the Jarmock farm whether on this property they were able to grow tobacco?
No, I do not know that.
All right, so is it fair to say you're assuming, and you may be assuming it correctly?
Yeah. I could,
You know a lot about this stuff. You know about this stuff a heck of a lot better than I do. But is it possible that they in fact could grow tobacco? You just don't know that?
they might be able to, but they're supposed to get valued on the use of what they're growing.
So let's talk about that.
Okay,
If the assessor's position is that he could classify it based on its highest and best use, irrespective of whether that's the actual use, do you agree with that?
no,
Okay, so if the assessor says, I believe they could do tillable B, let's assume he's correct. Let's assume you could grow tobacco, but they're using it to grow corn,
Mhm.
and that's tillable C. Is it your position that they have to keep it at that he can only evaluate tillable C's, even though you could use that land for higher and better use of tillable B? That's not their actual use. Is that your position?
yes. And that's the law. It's basically court cases on it.
So are you saying that the court case is for is it for farmland?
For farmland,
So, and is that in the state of Connecticut?
yes,
So is it your understanding that the court cases for farmland in the state of Connecticut provide that you have to classify the land based on actual use, not based on its highest and best use?
yes. And
For whatever it's worth, I have not researched that issue yet, so I don't
Okay.
know the answer. It's not a gotcha question. I don't know
Yeah,
what the answer is.
but then I'm gonna give you the other part of it.
Well, let me ask you before we leave that. Do you know offhand, and we'll obviously research the issue, we will. Do you know offhand, any court cases that provide that, those holdings?
Let's see. Okay, so, so the one that I gave you before of the Nelson, I think it's called Chickarelli versus the town of North Branford. That also, I think, and then there's actually determination of use value on the back of the PA 490, there's a bunch of cases. Did you ever get one of these books? Oh, okay. So on the use value, I think those would be your easiest. These are. No, it's fine. Okay. It's there. Last pages are there.
Okay.
Yeah, I don't think see anything spot on point that says you can't value it for highest, that you can't value on highest and best use, but rather for has to be on actual use, other than there's a case here cited, which is it's a holding within the Ristiki versus town of Stonington case, which is 174 con 10. There's a case it references, which is Stanley Goz is GOZDZ versus the Board of Review, town of Tolland, November 16, 1976, docket number 4634. And in that case, it says the plaintiff farmer, forest landowner, lost because he was arguing about the method of determining use value. The holding is that the assessor can use any method which would not utilize factors that may subject a land to a value reflecting a higher or better use than its actual use. So that seems to maybe support what you're saying by reference to another case. we have to read the Gazda's case, but that's interesting. So okay, see for a second. Actually, I want to make a note for my. That, I think that, all right,
So one other, there's two things on that I wanted to mention. So section 12-63, rule evaluation. It says the present true and actual value of land classified as farmland pursuant to section 12-107C as forest land pursuant to section 12-107D or as open space land pursuant to section 12-107E shall be based upon its current use without regard to neighborhood land or use of a more intensive nature. That's the rule of valuation.
and that's 1263. What?
That's 12-63. And
What subsection?
I don't know. This is in the CAAO handbook,
All right, so
5-31.
did you give me that or no?
Yeah, I think I gave it to you, but I gave it to you about 5 times in this thing.
Five
So
what?
You'll have it 5 times. It's on multiple.
Yeah, but page what, 530?
On this one, it's on LLO 67, because I just jumped ahead, but it's there.
Okay.
But it might have been on the last one, but I.
All right, so we're gonna mark it as or we're gonna mark it as we're gonna mark LL 67 and 68 as exhibit make sure over here. This would be I, so mark this as exhibit I. And what do you have? I see next year, Mr. Helms' resume. Is that correct? Will you provided me?
Yeah, I just wanted to go back to that one last thing that
Sure.
we didn't talk about on that page of LLO 28.
Okay, and that was exhibit I. What's that?
That was on the where Todd put it, the land in permanent pasture. the
Okay,
7
that's not
acres.
correct. I referenced the wrong exhibit.
Right.
So
But
you're
what I'm saying
referencing,
is that's what Todd did.
wait, a minute, you're referencing exhibit 300.
No,
I'm sorry, I'm sorry,
LLO 28.
PL 300, correct?
Yes, appeal 300.
All right, so that's exhibit D. Just trying to make sure it's clear for transcript. Exhibit D, so it would be page LL 28. So what were we gonna say again?
So the acres of the 14.22, that the farmer put in waste, swamp, ledge, and scrub.
Yes.
That was accurate because there was wetlands, and that is more indicative to the wetlands type stuff than it would be woodland in a farm unit. So,
And did you verify that on any mapping that the
Yes.
14.22 acres was in fact consisted significantly of wetlands?
yes,
Is that attached here?
no, I don't know if it's in this file, and it might be in the original appeal. I'm not positive.
So Mr. Helms' resume, you gave me that. It looks like a resume that starts with the town of Bloomfield. So is there a reason you provided this to me?
Yes. I provided it because people, the council members and staff were saying that he was an appraiser. And so I heard this from so many people, so I was thinking, all right, so he's an appraiser. But I went to the national database for appraisers, and he was never listed as an appraiser. And so that just brought up a concern. I later got a hold of the resume. I first wanted to verify whether or not he was or wasn't an appraiser. And it was, very misleading on the resume when he says he's a property appraiser. He says, he was a certified mass appraiser. And at Vision, he was a staff appraiser.
And by the way, we went over all this with him in his interview. I think I have a copy of his resume, and I'm aware of the fact that he's not licensed as an appraiser in Connecticut, but what appraisal type work he did over the years, including with the revaluation company.
Right,
Okay.
which he can do, but he's just not an appraiser.
Next, I see here appeal number 41. That is
Yes.
LL 42.
Mhm.
Why did you provided me with the summary?
Didn't take that one out.
Okay,
So it's appeal 42.
Yeah.
And it's a summary page.
yes,
And I'm sorry, it says appeal 41.
Mhm.
yes.
It is
careful.
page number LL 42.
Yes,
And then there's some pages after that. So the summary is here on page LL 42. Are there additional documents that are referenced in the summary that are here in the file? For example, you have rule evaluation, which
Right.
is 5-31 in the CAAO handbook,
Right.
which is been marked as exhibit I. It was you've also provided to me as already
Right.
as okay, and actually you did it twice, which is fine. So you have it right here attached.
yes, I tried.
Okay, that's helpful. And then I appreciate that, actually. It's very helpful to me. And then reclassification of the PA 490 farmland. You have pages 26 and 27 of the farm book. So those are attached here. I'm gonna put all this as one exhibit because this is helpful for me to do it this way. You got legal factors, which you took from the handbook.
Mhm.
That's section page 7-9 of the CAAO handbook.
Yeah.
And this is where, by the way, I think it's helpful to talk about stuff, and I want to hear your summary. The follow-up may be helpful when we have questions about a specific issue after we reviewed all the documents and started writing something. And then you've got
Ingress and egress and location.
yes, that's page 710 of the CAAO handbook, right?
Mhm.
And then you've got a map. Is that map part of this or no?
Not part of that. That was the first.
It's not part of this appeal.
Oh, no,
correct?
no, it is. It was just the next thing that I was going into.
I know, but I just want to make sure I have it all together.
Yes,
So-
oh, yeah.
so you've
I'll
got-
tell you when it stops.
Yeah, where does it stop?
All right, I'll tell you.
I'm just trying to organize it so that it's easier for all of us.
It stops at, the last page is LL062.
I know I could see what you did, and it's actually exactly the way I would have done it, so it makes sense. So I'm just gonna have one document where it all attached rather than 5 separate.
Yes,
It makes it more confusing the other way. So PO 41, you gave me the summary. And
so this.
tell me
was-
about it.
Okay, so this was a development rights restricted farm. Its developments were sold in 1983.
And by the way, this is just for the record, we're talking about appeal 41. And this is exhibit K in tight. And it goes from Bait stamp LL 42 to LL 62. You can proceed.
That's actually, now, see, we got our little phone
That's
great
that's
going.
a lot easier to say. Okay.
It just took us 2 appeals to get there, but
Oh,
we're
this
good.
is perfect.
Development rights sold in 1983. Property is landlocked, no access from a paved street. Pasture can be woods, so I just wanted to put where that was in the PA 490 handbook, because this is a woodland parcel. It has a power line easement that runs through the middle of it. Todd changed the classification of the land. He gives it an imputed lot value on the land. I'll explain that. Then, that actually can't have a residential lot on it. And then Todd puts that there was a change in use. And there was excessive value on the restricted parcel with an easement and no road frontage on a paved street. So this particular property, I previously appraised in 2010. So I had a lot of personal knowledge when I appraised it. And so I looked at Todd's notes when he started putting the little notes, and what they said, denial of PA 490 assessorly illegally changed classification of land. So the issues on this particular property, and I actually, let me go to my page, LL 048 is from my appraisal report from 2010 and 2011. So I wanted you to understand that I am familiar with this property. And I know that at the top on Bailey Road, it's a dirt road. It does not have access. I put the map in there because you can see the power line easement that travels. It's parcel A, the green parcel. If you look on my color coded, I tried to do it so that parcel A is green. That's appeal 41.
Let's mark it.
Yeah.
Thank you.
Okay. The next page, LL 049, is from my appraisal as well, because it's a wooded lot. And
See your color.
Yeah.
I may have to switch them out because it's going to be too hard for me to do it in black and white. If you don't mind.
oh, yeah, sure. I'm sorry.
That's fine. It's just that it's
You want both of them?
yes.
Okay.
Otherwise,
Yeah.
I'm not going to understand it.
You were supposed to do it.
Different piles, yeah.
Yeah,
So if
got
I
each
choose
other's
colors,
piles, yeah.
I'll give it to him.
Looks like I could always print it out.
Yeah, that's fine. I
Mario, I'm gonna send you a scan version of this, so you'll have that.
Well, it's actually helpful the way we're doing it, so that's fine. Okay.
So, Todd said that the use changed, but it was like a wooded lot when I appraised it in 2010. And it's still a wooded lot from the aerials that were in there. So I didn't know why he wrote down there was a change of use. And then he changed, I guess, the classification on it from woodland to pasture to woodland. But I ended up noticing about the lot, the imputed, what I call an imputed lot. This is like so a lot of assessors will take a piece of farmland that doesn't have a buildable lot on it, and they just put a lot on there. And so they can add a value on a parcel that actually doesn't have a lot. And it's not for zoning or whatever, but this particular property is deed restricted, cannot have a residential lot on it. And this deed, the very first deed that I showed you, which was exhibit.
I remember.
Okay, that is actually this person.
Well, what you're talking about is the example you gave,
Yes,
which is exhibit C. So
Mhm.
what's the property address here?
this is, let's see if I have the address on it.
I think it's 1 Bay Street.
It's 200 Fletcher Road is the actual street address.
Oh, so, okay, I was off. All right, so 200. So this is 200 Fletcher Road, Enfield, and it's also BAA appeal number. Which one would appeal number?
41.
Okay. Is there anything else you'd like to tell me?
Let's see. Oh, it had the assessed value on it, which on this one, it was $4,297 an acre, and it went to 10,148. Which the 4297 I thought was a little heavy, but in the ballpark, and when it jumped to 10, it was way high.
You mentioned that you did an appraisal. For what purpose did you do an appraisal on this property?
I believe I was working at around farm credit, so
So it's fair to say you didn't do it for the property owner, you did it for another
Right.
entity? Okay.
this name you're familiar, because
Next, I see that you, on, LL 64, it's a special factors affecting lands.
Mhm.
It looks like an excerpt from the CAAO handbook. Why'd you provide this to me?
that one is for LL's, that's for the next appeal, which is gonna be appeal number 297. I can give you my note, that would help you probably,
Oh, okay, I didn't have that. Okay.
yeah, you don't have that.
So, yeah, it's much easier with your notes, quite frankly, especially since you drew stuff out on this one. So this is appeal number 297, and let's just make sure we get our ducks in a row with the document. So we've got the excerpt from the CAAO handbook. And then it looks like this is and you give me the appeal.
Mhm.
With Todd's notes on it, and it looks like I have some other notes.
Yeah.
And what is the last page?
LL081.
I can see what you gave me. But the only thing is some of the stuff you gave me is not in color.
Okay, so I'm gonna go through and see anything I have in color, I'll give it to you.
For example, why don't you swap out page 81?
Can you just follow from here on out, anything?
Whatever's easiest. We're gonna mark this as exhibit L of Larry. And this is appeal number 297. Okay. What would you like to tell us about this?
Okay, so this was I call it the Maturo Farm, even though it's owned by Jarmox. It's a development right restricted farm. Restricted to agriculture. There's a landlocked piece of land on this particular property. Todd changed a residential restricted parcel to commercial. And he also changed it to a more intensive use. Todd gives Jarmox 3 values on this property. It was 361, 670, goes to 384, 900, then 441, 900. So he reclassified development right restricted land, which was on the Farm Bureau book, 26 to 27. The rule evaluation he violates because of the current use as a farm. Some legal factors, because you're supposed to know about zone, deed restrictions, and easements. And number 4, ingress and egress, the part of the land that was landlocked. Della, the previous assessor, had the piece landlocked on this one parcel, and Todd removed the landlocked part. So I literally got in my car and drove down to the parcel so that I could see with my own eyes why Della had landlocked one piece of it and why Todd removed it and what I would be looking for. And then I just drew a little like sketch so I would remind myself that there was a water body. It ended at the road again. You know, the dirt road ends, the paved road ends. It's then no longer a street. The landlocked piece couldn't be accessed, and that's why she put the landlocked on it, and he removed it, and then he took his barn, metal barn, and that he's using for farming and made it a commercial building.
We take a break at some point just
Sure.
for like 10 minutes.
Perfect.
Okay. So we're gonna do that now. Hang on, let me just make sure I'm gonna. All right, we're back on record. So appeal, we talked about appeal 299, which I marked as exhibit M. And you gave me a summary and you gave me some additional documents with it, which go from page LL 82 to LL 99. Why don't you tell me about it?
Okay. Appeal 299, this is, the land was appraised value at $199,400, which was $14,273 an acre. And then on March 24th, the same land now valued at $631,370, which was $45,194 an acre. Jarmark in 2021 wanted to clear the land to farm it. So they put what they were going to farm, and Todd puts his own acreages down. And I pulled the soils map to see again who is correct. And the value of this farmland was grossly excessive at $45,000 an acre for any land that's restricted. And I felt like it was 12-63 rule valuation. I want to know who increased this value so high. Then I know that there's an audit trail that can be done. It must be assessed uniformly with the same level of values in the handbook.
Can I stop you right there for one
Yeah.
moment? Only because I mean, it's helpful for you to keep going, but every once in a while I'll jump in if you don't mind. So when you said an audit, and does he do this with everybody? I mean, it looks like here he was at 45,194 an acre for the excess land, for the farmland. Is that correct?
For the farmland.
And that seems to be consistent with others that you've noted so far, correct?
No, because I only found one other one that was that way.
Well, there's one you pointed out so far to me,
Yes.
which was okay.
Yeah.
So you're saying that all others seem to have been much different in value from 45,000 per acre?
Yes, some of them were, yes.
And what were those others?
There's a few in here. I
Okay.
don't know exactly, but
Yeah, well, I
saw
mean,
some excessive ones on these, especially if they were restricted land.
but when you talk about restricted land and we talk about the rule of uniformity,
Mhm.
I mean, even if you could still value, could you still value acreage of restricted farmland for different values based on the land being different or the property being different, whether it be for the location or for type of soil, et cetera?
It's supposed to be based on the use of it. But if it was maybe an industrial farmland versus a residential farmland, maybe that would make something a little bit different, but it's use is use is use. It's farmland.
So let me ask you
And
this.
it's restricted farmland.
So, but you said, we talked about uniformity with regard to restricted farmland. Is it fair to say that one property, I could have a property that's restricted farmland where I could be growing corn.
Mhm.
You could have a restricted farmland where you're growing tobacco.
Yeah.
So my value per acre is going to be less than yours.
Maybe, but when you're doing restricted farmlands, you are solely restricted to agriculture. So their farmland spread is much lower than a regular non-restricted farm parcel.
When you have restricted farmland, are you still applying the tillable A, B, C categories, classifications?
No, we do base it on like overall like soil capabilities. So if you can grow tobacco versus corn versus whatever, it would be what your growing fields.
When you say we, who are you referring to?
Well, like the state of Connecticut, like when I'm appraising them.
But for an assessor, is it improper for an assessor to use the to value the land based on a tillable A, B, or C classification if the land is deed restricted for agricultural use?
I don't have the answer to that, but I could see if, I don't know that. I don't know the answer to that because I'm not an assessor. So.
I mean, I think that's where we could have a different, there could be, I'm just trying to.
So can you
point out-
repeat that question? Just
so,
so I want to understand it. Then I.
So the question is this, it sounds like one of the arguments you're making is that, one argument you've made is that, that the assessor has ignored the fact that some of these properties are restricted for agricultural use,
Mhm.
and that he's ignored the deed restriction.
Yes.
Okay. Another argument you've made, I believe, is that that he has improperly changed the classification of farmland for certain properties from tillable, C to tillable B, moving it up a classification based on highest and best use, which was different than the actual use. And that if the actual use is a tillable C category, is tillable C, that you cannot move it up to tillable B just because he thinks you could farm it for a higher and better use.
Right.
And that's number two.
All right. So that I can answer. He can't, it has to be on the use of what the farmer is doing it.
You were clear about that.
Yes.
And
Okay.
you also cited the PA 490, a provision for the PA 490 handbook, and there are two cases there, Ristiki versus Stonington, and the other one was Stanley Gotts versus Tallinn, which I've written down here. So, again, the basic proposition being that that the land, that the value cannot reflect a higher and better use than its actual use. Now, your third argument that you've opined to is that, correct me if I'm wrong, is that with regard to the manner in which he valued each the amount that he valued per acre for some farms was significantly different and improperly different than others, to the extent that it violated the uniformity rules set forth in, I wasn't far, I said 1264, off the top of my head, it was 1263. So off of they violated the rule of uniformity, which is 1263C. I'm sorry, 1263. And is that correct?
Yes, I think that's the right statute.
No, it is. I'm reading it right.
Okay.
Based on your notes, I'm going to assume you're right. So
Okay.
what I'm saying is that's your another argument you made is or position you took was that you think that he violated the rule of uniformity because he valued the discrepancies in the way he valued farmland was so different from one farm to another, correct?
Yes.
And what I asked was, well, isn't it possible that you could have one farm that's valued at $45,000 an acre and another that's valued at some substantially different number, like $15,000 an acre, because there's characteristics of farm A that allow the assessor to value it higher than on a per acre basis than farm B?
No,
And tell me why.
because if it's on farm A and farm B, if somebody is farming corn and somebody is farming tobacco, the assessor is not supposed to be he's supposed to be looking at the land class. And if I don't have the values here, let me see, because it would help me if I knew the. Okay, so basically there is a price difference. So on a tillable A,
Mhm.
it could be 1880 an acre, and on a tillable B, it could be 1280 an acre, and a tillable C, it could be 1110 an acre. So there is a slight variation, but it's not going to be something that is from like 1880 an acre to now $45,000 an acre. There's just a
But-
huge discrepancy.
What- Okay, but is it fair to say that the assessor could value an acre of farmland, farm A different than farm B if, for example,
If farm A is a tobacco and farm B is a tobacco, they should be similar.
okay,
if-
but let's assume that instead of using A, we're gonna get more confused. Let's farm the cat farm, okay? So cat farm has is tillable A. Cat farm is tillable A, and dog farm is tillable C.
Okay.
If that's the case, and under those circumstances, wouldn't there be a different, a substantially different value for the cat farm than the dog farm?
It would be $400 an acre difference.
So not a big difference, is what you're saying, okay. So let you keep going.
So. Okay, the increased value was high. I would say an audit trail, not for me, but for you. So you could go in and look and see what the audit trail was. And then. The inflated values, my issue with these inflated values. Comes from when the farmer dies. The estate uses these values that are on the cards. And they use them for gift purposes, and they also, if they fall out of PA 490, they could pay their penalties based upon these inflated values. So that's where these huge amounts really create a problem that sometimes the farmers aren't aware of, but that I'm seeing these values that could be troublesome down the road.
Mhm.
So the farmer is looking to make sure that they're paying off of their PA 490 value. A lot of times they're not looking at the appraised value, because in the end, they really are only seeing what they're paying. So they're not realizing that these properties went from 199,000 to 631,000 for the same property in this revaluation.
Big difference.
It's a big difference.
So essentially it went up more than 3 times. So for appeal 299, the subject property assessed value by the town went up more than 3 times.
Yeah.
Next, and is it fair to say that one concern you have for farmers in the community based on what you just talked about was that if somebody passes away, it affects their estate tax potentially, or
Right,
value of their estate.
right.
We're on appeal 319. That's exhibit N as in Nancy, correct?
Yeah.
You want to tell me about this one?
Yes.
Well,
This-
but by the way, overall, the value jumps from around 300,000 to 600,000, so almost double. Is that correct?
Yeah.
Okay.
And so on this particular one, Todd put a note on the sticky pad for us that, per GIS, no swamp, 5.8 acres of woods, rest of the property is tillable, added missing barns. So, the first thing I did was go to the aerial, view. And I could see the actual barns on the aerial view, so I knew the barns were there, okay, so I did see, I counted out, 1, 2, 3, 4, 5. Is yours might be the colored one, so you might be able to see it, because I think I highlighted the barns on there. But I went back to see, like, if the barns were legitimately, so the barns, I could tell by the card, just looking at it, and, we've been doing it for a while. So in this particular card, the old card, it had a lot of graffiti on it.
Mhm.
Okay, and I live in this town, so I drive by these places. The new card just shows a new picture of the barn, and there's obviously no graffiti. But what I found was on this, Todd turned and made these old barns new. So I went back at least, I don't know, 20 years of aerial views to find out that these barns were on the property for the last 20 years. And so he turned around and made these 5 barns 2021 barns. And so then that made these particular barns $63,900, $63,900, $51,100, $26,600, and $6,400.
So is it fair to say that there's a significant increase in this property value because he changed the condition of the barns?
Well, he changed the year on the barns were brand new barns. If they were in fact missing from the card, which I don't know that that's the case, but let's say that they were missing from the card, you should do your due diligence to find out, well, how old are these barns before just saying, okay, I'm gonna make all these 6 barns brand new barns.
So
If they weren't not new barns.
So is it fair to say that here he valued the barns that they were built in 2021?
21, yes.
And in fact, you believe they were built, it's your understanding they were built when?
Well, I went back, I think, 20 years in aerials to see, and I knew that economic life of a barn is like 25 years roughly. And they were at least there 20 years ago.
So they're over 20 years old.
Yes.
So he was off.
Yeah.
Maybe by
So-
20 years,
right.
okay.
But my find is like, this is stuff that you should really want to be accurate on and not like you just, okay, I'm gonna make them 2021 and let's see the person come in and fight it. You know, it was like kind of a disregard for the truth. I feel like he loses credibility with his notes when you know, and so on this particular property too, where the barns were, he said there was no swamp on this little sticky. But I could clearly see the swamp on this particular property because the swamp is right here in this.
What page are you looking at?
It is on page. It's the last page.
It's 109, but
Yeah.
the bottom line is you don't have a color copy either.
I don't have. a
Okay,
color
that's all I
copy
wanted.
either, But this was Todd's, what he put in the report. But I could see right here, this dark area is all the swamp. So he was claiming there was no swamp, but I know that that's a swamp. And if
So,
you saw it in the color photo, you would,
so the area that jets out is swamp.
yeah, and that was a swamp. So,
So this part of property is, in fact, you're positive?
that was swamp. And you could tell.
Okay,
And then the rest is
okay,
pasture.
got it. Next is appeal 3, that's helpful, 353, right?
Yes,
And that's exhibit, O is an Oscar.
yes.
So tell me about this one.
Okay, so on this property, I asked Vicky to obtain a zoning map for me from the Planning and Zoning Commission. The property goes from 555,480 for this farm to $747,200. Todd adds an industrial value at $120,000 per acre to a residential lot that's R44. So this is the zoning map. And hold it up so you can see it.
Mhm. Will you just tell me where it is?
I'm gonna find it for you. Right here. Industrial 1 is this parcel that's not subject to the appeal. The green is the farm subject to the appeal.
Okay.
Okay, so,
By the way, can I have a copy of that map?
yeah, I'm sure we can get you one.
I take that one or, Would you be able to get another copy?
I'd have to get it from the town of Enfield.
Okay, I mean, I'll pay for it if there's a
Yeah.
cost.
Okay. So it's zoned I1 and then, and how and I'll give you this piece because this one is colored.
What page
Okay.
is that?
This is gonna be the LL 115.
So on 115, let me swap with you, please. So basically, he applied the wrong zoning, he applied the wrong zone. He applied the wrong, he applied the zoning map incorrectly. And is it fair to say that he did that?
Yeah, he took a farm and he added an industrial land to a farm that's residentially zoned. I guess it's the best explanation.
So he basically, so is it fair to say that? So did he, let me say this way, did he value it for use that's not permitted in the zone?
Yes,
So he valued it for an industrial use, but but an industrial use is not permitted in the zone.
right,
And you're an appraiser, correct?
yes,
And is it your understanding that one of the first rules, if not the first rule of appraisal methodology, is to determine whether the proposed highest and best use is in fact legally permissible?
yes,
And in this situation, where you believe that the use that he applied, which was industrial, is not legally permissible within the zone, is it therefore on that sole basis alone improper to have valued it based on an industrial use that's not actually legally permitted at this time in the zone?
yeah,
And even if you could get a variance, would it be improper to value it based on that highest and best use if the property owner does not in fact have the variance?
yes, and it wasn't the use of the farmer.
Aside from that,
Aside from
all
that,
got it.
so that was that one. And then on this particular one also, there was what I call them qualified exemption, like, so the wife dies, the land went to the husband died, and so it was all for no consideration. And when the person had come in, I guess they were saying that he was changing them from PA 490. And I believe that was the reason, but I added that on there just so that was like the fourth thing. Like, these are all kind of like eye-opening things for me. Like, I just sit there and I'm just perplexed at the amount of the stuff.
Okay, that's appeal 353. Next, appeal 221.
Okay. All right, this is the Moose Club, and they went in and met with the town manager, Ellen, with approximately 400 pages of documents. Ellen indicated that they were all set and that they had proved that they were tax exempt. They filed the appeal with the BAA as an assignment. Okay, and he told me this, okay, that this came out of the hearing. He said she kept the documents, they came to the appeal, and they said to me, do you have all my documents? And I said, no, I don't have anything. And they were like, I said, but since I don't have anything, I can request them from staff. Because if you brought 400 pages of documents, I know my stuff was only a few hundred pages. Here, 400 pages of staff was like this. So they said, well, we will copy it all if we have to, but we gave it to the town manager. So she has all these documents, and we thought she was giving them to the board, but you know, they should be in the assessor's department or somewhere. But nevertheless, we did not get them. I asked the staff multiple times. I asked Vicki, I kept asking every single time. I wanted to see these documents. On one of the last days of our hearings, I needed it was the day before the last, because I needed these documents. Otherwise, I was gonna have to call them up, have them copy them so that I could see them, so that I didn't have to deny them based on I didn't have any documents. They brought in the stuff. I had to look at them during a hearing. I saw that they have the 990. I looked at their calendar. They had all the supporting documents claiming that they were a charity. The calendar indicated that everything they did was a charity. I actually went into state statutes to look to see, because Todd had put on there, does not qualify under state statutes for exemption. Found all other moose clubs taxed in other towns. Nonprofit 501c3 does not automatically qualify a property for municipal exemption. So I literally went through all of the documents and the state statute, and it did say that if they were a charitable, exclusively for charitable, it counted as real and personal property. And when we deliberated, we took all of this information and gave them back the exemption. But my biggest problem with this was the withholding of the documents. I lost sleep over this because I so needed these documents to be able to rightfully look at their case. And I just didn't think it was right for the staff to withhold the documents. And then when I got the documents, they told me I couldn't copy them. I could look at them at the hearing, and then I couldn't keep anything. But I insisted Vicky go upstairs and use the town clerk's copier and copy a couple pages so that I could actually prove that I looked through those 400 pages of documents.
It appears in Paul. So did you say that the assessor only, the records that you believed were relevant for purposes of being able to examine this application, he would not allow you to have a copy of, is that correct? And but rather, he wouldn't let you or anyone from the BAA take the documents into the room where you were conducting the meeting?
Right, but on the second to last day, Vicky turned them in this was after, like, they came in on the very first days of the appeal. 3 weeks later, that's when every time I would be like, Vicky, can you find these documents? Town manager has them. You turn them into the town manager. Does Todd have them? I mean, every single time.
Well, when you actually got it, but at some point they let you look at them.
Yes, in the hearing, they let me look at them.
In what office?
We were downstairs in the.
No, but not where you gotta go. Where did you have to go upstairs?
Oh, no, she had to go upstairs to the town clerk's office to copy the few pages I insisted on having in the file.
What did you see all the pages?
Yes, they finally turned them into me that day. I was doing
Or
hearing.
did you? I thought you had to go somewhere else to go view.
No, I didn't have to go elsewhere. They finally brought them to me.
So they refused at first to give them to you, and then eventually did.
But that was the thing. It was withholding these documents. There was no reason for it. That they wanted me to have the documents. That was proving their whole case. And if I wasn't the type of person that I am, like, I'm very organized and I like literally kept making notes. You're talking 400 appeals and I'm trying to keep them straight in my head. And that one I was most concerned about, because if I didn't have the documents, I was going to have to get them to copy them before our last day of the hearings.
And on page LL 136, there's a note from Todd, appears to be a note from Todd, which says that he found out that all other moose clubs are taxed in other towns.
Yes.
Did you ever verify whether that's accurate?
No, because I did not.
If there's other moose lodges throughout Connecticut that are in fact taxed and haven't been appealed by a moose lodge, would that be information that would be relevant to your inquiry here?
Well, it would have to pertain to the fact that Enfield Moose Club said that they were all charity work. They only did charity work. I don't know what the other moose clubs in the other part of the state did. So moose clubs it's like a fraternal organization. They can, different branches do different things. They might do some charity work, some other stuff, but in Enfield, they were claiming that they only did charity for the entire calendar. And that's why that calendar I thought was really important, because their calendar documented that they did nothing other than charity work.
Let me ask you this Moose Lodge in Enfield, does it have a hall or any sort of facilities that can be rented?
Yes, I don't know if it can be rented, but it has a building.
Is there a hall?
I don't know, never been inside of it.
Is there an event space?
I don't know that either.
Is there a bar?
I have no idea.
Let's assume, and I don't know, because I don't know what this place is, but let's assume that this Moose Lodge has a hall that could be rented. If in fact the Moose Lodge had a hall that could be rented or deriving profits or rents on an annual, throughout the year, would you have still made the same decision to grant their appeal and exempt it?
I don't know.
Their application states here that, and I'm on page LL 136. It says, the reason for the appeal, we are a 501c3, not for profit by the IRS. Do you see that?
Yeah.
But just because a property owner is a 501c3 and a not for profit, as determined by the IRS, doesn't mean that any property it would own in town would be exempt, correct? But let me ask it this way. That's a presumptuous question. Let me ask this way. If an organization is a 501c3, recognized by the IRS as being a non-qualified nonprofit organization, and it owns property in town, is that property in town exempt from taxes irrespective of how they use it?
I don't have the answer to that. I'm not an accountant, but I will tell you, this is I catch that. So one LL 135. So on their exempt 990 form, the word that I basically circled was charity, because that particular, they said they did only charity work.
But do you see that page you're referring to, which is
Yeah.
L135?
Yes.
Do you see where it says, if you look down in the revenue category, do you see that they apparently have revenue associated with this property, which is crossed out?
Yes, I crossed it out.
So did you have an opportunity to see how much revenue they had?
Yes.
How much revenue do they have?
The exact amount. I do know that they said that what revenue that they came in went out for the work that they did. Like they did fundraising, that revenue came in and it went back out to the charity that they did. Like they did Alex's Lemonade. They did a special fundraiser for some cancer stuff. So what came in and it came out. So their revenues, I believe they were showing the revenues of what came in. And they said that their revenues go back out to the charities. They did some stuff for the town of Enfield. They did things for senior citizens. This calendar was very encompassing. I can only say that their testimony and what I had applied to them. I don't know about other moose clubs. And when I will tell you in that thing, because I made some notes, if you look on my thing, they gave 10 years of 990s,
But if we look at the
4
act,
years of the past calendar, the donation list, minutes. The issue really isn't how it was decided. The issue is the fact that they withheld the documents.
I understand that part of it. That's, I don't know why that was done. We'll have to find out. The document you gave me included page LL 133. Do you see that?
Yes.
And that includes an excerpt from the CAAO handbook. And you see where it says lease property?
This is the state statute. This isn't from the CAAO. This is the Connecticut state statute.
Well, LL 133.
Oh, yeah.
It's
That's
not-
the number 133, but
It's actually from it's from an office. It's actually not from the CAAA, the CAAO report. It's
Right.
actually from an
office of-
article that you got from OPM. And it was a report issued in June of 2020. Thank you for correcting me. But on that page LL 133, in that report, it talks about lease property for qualified nonprofits, correct?
yes.
And the first sentence, what is the first sentence under lease property state?
Property of a nonprofit leases to other and collects rents on is exempt. So long as it does so in furtherance of its tax exempt purpose. For example, the Connecticut Supreme Court held that a halfway house that provided housing and rehabilitation services to individuals under the Department of Corrections supervision was tax exempt. Even though it collected rent, it held so in part because the halfway house collected rent solely in the furtherance of and in direct relation to its charitable function of facilitating inmates' transitions back into society.
And I think that example makes sense. And I don't know if the Moose Garage derives any revenue. It seems like it does based on the document I saw on LL 135. To the extent it does, I don't know for what purpose it's or how it's deriving that revenue. if they're renting out a hall, I guess then the question may be whether the revenue they're deriving is in furtherance of its tax exempt purpose. And as I sit here today, without knowing enough about the Moose Lodge and not knowing about what revenue they may collect and to what extent it may or may not be related to its tax exempt purpose, I don't have an answer as to whether or not they should be exempt as I sit here today. But when the BAA examined their application, was there any consideration of whether the revenue they collected, whether it was in fact related or used to further its tax exempt purpose?
Well, they were very specific and said that the only that they did all of this fundraising, and whatever fundraising they did for that particular item in the calendar went to that particular event. So money in, money out.
To the charity.
So, yeah, to the charity. So if it was Alex's Lemonade, if it was the Enfield Dog Park, or, you know, whatever that they had on their calendar, the stuff that they did for the town of Enfield seniors, money in, money out. So
Was there any, do you know if they had any staff that they had to pay as part of the money out?
they never said anything about staff. I only have the calendar, you know, I mean, they talked about the calendar. And they were very specific about showing pages in the calendar and stuff. But I really wanted to see the documents that they had turned into the town. And like, I'm an appraiser, Tom's a lawyer, Donna is a real estate person. None of us are accountants, so.
Okay. Next is appeal number 281, and that is exhibit Q. It's in Queen. Okay.
This was an imputed lot value. Again, adding a lot value that's not on the farmland. Property had a missing barn. I went out actually and I saw the barn and I added it to the appeal. So whether it was pro, con, it didn't matter. I found things that either weren't on something, I added to make sure that they got on there. On this particular thing, when I went out to look at the farm, I saw this barn that wasn't on the card, so I actually added it in there. Per the zoning map, we did not see a building lot on this farm. It's being used as a farm. And again, this property actually is around the corner from my house, so it wasn't too hard for me to drive over and look at it. And so on page LL 142, I write on there, added in the barn. That wasn't on.
All right, but that happens
Yeah.
sometimes. I mean, an assessor may get something wrong, and that's why somebody appeals and says, hey, you got my square footage wrong.
Right.
You're missing a barn, so that makes sense.
The point on this is we were just doing what we saw.
I got it.
So,
And it's the same thing with somebody could have, like the example you gave, which is a good example of, you have a barns that, where the year is 2021. Maybe it's a mistake. Maybe it should, the actual year of construction was 1991. And, assessors make mistakes or reval companies make mistakes. And that's why one reason why we have a Board of Assessment Appeals process that's allowable under General Statute 12-111 to give property owners an opportunity to have those things corrected. Next, I have Appeal 38, and that's Exhibit R as in Robert.
okay, this one was an elderly woman came in. She'd been farming with her husband for 50 years. The husband died. She continued to do farming, but in a smaller capacity, like around 4 acres on our property. She had gone to the Enfield Farmers Market up to COVID. Todd was removing her from PA 490. He told her, I guess she didn't have enough income, she wasn't farming. And he also told her she needed a forester's report. In this particular appeal, she only was appealing 4 acres, and so I didn't understand why she needed the forester's report. But she went out and spent $400 for the forester's report. She got it, brought it into us at the hearing because she said Todd told her that she had to get it. But because the husband died, if there was an active forester's report, it should be an exemption and she shouldn't have had to have gotten it. But she made a point of bringing it up. So I wanted to point out that lack of income does not mean you terminate PA 490, and loss of productivity can be from old age, accidents, or death in the family. And in her case, she was doing this up until COVID hit and they stopped doing the farmers markets. And so that was this particular case. And I still don't know about the forester's report, but the forester's report is in this application because she supplied it.
Next is Appeal 280. It's I have it as Exhibit S as in Sam, and I see that the value of the farm, which was deed restricted.
There's pages here. I have appeal 228 and 7. So
Did I grab too many at once? Sorry about that. I had Appeal 281 was Q, and then I had Appeal 38. Is that correct?
38 is R.
38 is R. Let me just get that.
And then I have 227 and 228 and 7. That's my next appeal.
I don't have that. I don't have that document.
This is the one I have next. And then 280 is after that one. Unless, how many pages was that one that you just flipped?
A lot.
But I bet you it's stuck in there.
Oh, yeah, it is probably. What is it on?
It ends at 183 and it starts at 160.
Yeah, the one that's R was 147 to what page?
Was 147 to 161.
Okay, so we had it wrong. So not a big deal. Have to get to the double letters here. Okay. Ooh, so that would be, and then 228 and 7 was 162 to what?
183.
Okay.
So what are we making that one?
S is in Sam.
Okay. So everything else is
I'll move them on. That's okay.
okay.
All right. So tell me about Appeal 228 and 7, please.
Okay, Hunter's Cove and Grassmere. They were both in open space for over 20 years. Grassmere for 39 years. That they knew of. Both were listed in the Plan of Conservation and Development and the deep open space map. Todd removed both of them, claiming that Enfield had no open space in their regulations, but open space was in the zoning regulations. And this was the equitable estoppel. They brought in a couple cases, but basically preventing from asserting a claim that contradicts what one has said or done for all these years. But so for 39 years, the golf course and the Hunters Club relied on this open space. Somebody had actually classified them that way. They're in all the town maps, they're in the zoning regs, and they're in deep. And Todd removed them. And then we put them back.
Do you know why you removed them?
He's saying that we don't have the the open space that is in this book.
We don't have it. You mean it's not designated?
Enfield.
So as
is
a
not
clerk
one of
said,
the towns listed.
So that his position was that the statute requires that the municipality designate open space, the open space within the community. And that it hasn't. Has required under the statute, and therefore was, well, equitably stopped from now changing that classification, because even if it's not justified today, they're grandfathered in, or it would be not grandfathered in. It would be the town is inequitably stopped from taking it away 39 years later. Is that what you're?
And the fact that the plan of conservation books were approved by the body. So the plan of conservation books for 99 and 2011, and I'm going to give you these because this is the colored version. You're going to like this one.
What page is it?
That is LL 163, and then you're going to want LL 164.
I'll show you.
Okay.
We got it.
Through.
Got it.
164, and then see, this is the part. So I put
I
these
got it.
in because these were adopted by the body. And then this is one of the DEEP maps showing that the Department of Environmental Protection also for years has had listed both Grassmere and the Hunters Club in their open space, municipal open space. You want this color one too, I think.
What page is it?
LL 166.
I thank you again for page stamping, Miss Rachel. This is very helpful.
And then this one is LL 171 and 172. Mine are colored. So you're gonna want those too. You'll want these colors too.
Thank you. All right, next we have Appeal 280. That is Exhibit T.
Okay, 280 is. This is a development rights restricted farm. Went from 336 to 540. Todd reclassified the farm as field. I checked the soils and I used the 2018 sale. Oh, in one of my appraisal reports. So I had done the research on the property. It did have the ability on this particular property. The deed had the ability to build one house. Remember I was telling you about farmland for land that is restricted and sometimes they don't have the ability to have any house lot. But on this particular farm, it did have the ability at some point in time to have a residential house on it. Even though it's not there and it had the capability, I left the building lot value alone for that fact.
Okay.
Okay, it would have been a rear lot. It doesn't have frontage. I don't even know if it could get approved from planning and zoning, but because it had that ability in the deed, I just left that part of it.
Okay.
But what I noticed was the farmland was 9,000, and that the classification on it was recently submitted and approved, and then it was changed. So that's where I was concerned, because it went from what the, let's say the owner had is B, swamp, and C. Then there was just some changes in the classifications. So that's what the concern was on that particular property.
Okay.
Okay.
Next is Exhibit U, which I have as starting with page LL 199. It was an example of excessive value that was in the 2021 grand list, but not appealed.
Yeah.
Okay, I get it. I mean, I can see what you.
So on this particular property, it was removed from PA 490
Well, why are you bringing this up if it wasn't appealed?
because it was about the excess value. So the council in their MOU wanted to know about, is this just was this townwide, or was this a narrow scope and just for these particular farmers? This particular property is my own property.
Okay.
I did not appeal this property. However, because he then reinstated it in PA 490. However, the values I noticed changed. That's the I know myself, a lot of properties that didn't come in for appeals. And I don't know if their values were doubled or tripled like these. So that's the point of the excess value. This value was doubled.
Um. The next is L 208. I have it as Exhibit V as in Victor. I'm aware of this whole issue, so I don't think we need to spend a lot of time on it. I could just, I have thank you, I'll put it in the pile I have, but we've already been over this with others.
Okay, because it was like
I got
literally chaos.
Yeah, I have. We've been over it with others and I asked the assessor about it. W, exhibit W, starts at page LL 213 and it's a significant document. My understanding is that you're providing this with me, to me regarding barn values all over town.
Yes,
And that, is it fair to say that, are you providing this to me to show that he did not value barns consistently throughout the town?
yes, that was part of it, but we also had the barn value, so Owen Jarmuck did what I would say is a regression analysis. Okay, it was specific to Enfield. It was more Enfield, that more work than Vision did. Tobacco barns typically have no floors.
Mhm.
And so you have to understand that all barns are not equal.
Understood.
As an ag appraiser, I track barns values, okay, and his barn values were actually in line with my values that I've been doing for the last 10 or 15 years. The townwide barns he put on the spreadsheet, he actually went and got every single barn that was listed on a field card that he knew in Enfield that was related to a farm. Then the very next page, LL 219, after that group, is the Vision barn values. Okay. This is the book that we had to pay $100 for.
Mhm.
And we had asked for in other years, I believe the board had asked for this Vision book. They had to pay the $100 for it. I decided to look at the book, and things on their outbuilding codes totally didn't make sense to me. So they had a pole barn at, it says 10, I think it's feet, and it's a WH, and it's 2130, the unit price. And then an 18 WH is still 2130, and a 24-foot WH is 2130. So just looking at these values, and anytime that I asked a question about Vision, I was told that it was proprietary. Like if I asked about a cap rate, it's proprietary. I asked the question, well, who was the brokers that, they make mention? It took them weeks to get back to us to say that it was this woman out of Wallingford, and it said in their valuation parameters that they talked to local brokers and real estate agents. And not for nothing, but there's a real estate company right next to the town hall between Todd's office and the town hall. They could have very easily talked to real estate agents. The Vision issues is part of this with the barns, because we asked for this book, and like on our page, this is not signed. Okay. Then that was on page 220. Then on 226. All the people that they reference as been working with this on the property, none of them show up as appraisers. Okay. Which then only comes to then on LL 227, and you probably, mine is very lightly highlighted, but you can hardly see it. But it says here, the appraisers in number 3, number 4, the appraisers, in number 6. So number 4, the appraisers assume no responsibility. So honestly, they say that there are no appraisers, but then the valuation parameters and the assumptions and limiting conditions indicate that there should be appraisers, or And it's the same with on LL 228, number 14. Every attempt has been made to verify this information by the appraisers and is assumed to be reliable. Number 15. The existence of the hazardous material may not be present on it was observed by the appraisers. The appraisers have no knowledge of this. So they are using the terminology that there are appraisers doing these valuations, but I didn't see any appraisers that were doing the valuations. Then on LL 230, they do a certification of value, and that one's not signed either.
Okay.
You know.
Okay, I got it.
Okay, and then I put in on LL 231, 232, 233, 234, 235, and 236, 237, and 238, 239, that in 240. Are all, and 41 are all use map requirements for mass appraisals.
Yes.
And the reason why I did that was because on one hand, they say that they don't need to comply on some things, but then they're stating that they're following USPAP in other things. You go to USPAP and they're supposed to have appraisers if they're doing this, and these appraisers are supposed to be signing these certifications. So it's kind of like they say one thing on one side, one thing on the other, but they're not really doing any of it. Quite disturbing. Then on page LL 242, I started to notice that, so the vision book, which by the way is here, is the most crazy book you'll ever see. Because this is the book, how it was handed to us. Okay,
I have the budget book.
and then hopefully your pages aren't messed up and backwards like ours was. So I don't know if you really looked at the depreciation schedules or any of
I was gonna
that stuff.
get there later with you.
Okay,
I'll get there with you. All right.
because our books, they were all like reverse order, like somebody printed it out and didn't put the order in correctly, but I basically,
Are you moving beyond this exhibit W?
no, we're still in the same one. My W was about the barn values, but it fell into the vision stuff. Because I noticed that the vision was part of the barn values.
Okay.
So I put in all that use map stuff. So on the vision stuff, then I also noticed that the neighborhoods were not correct. So but they're talking about neighborhoods, specific neighborhoods. These neighborhoods are not the same neighborhoods. So unless you know Enfield well, you might not know that, you know, Celtic Court and Shannon Drive are nowhere near Deer Run and nowhere near Clinton Lane.
Is that a fair, but is it fair to say that's your opinion?
Yeah.
Okay.
It would be my opinion.
And others may agree with you, but others may disagree with you as to whether there should be significant locational adjustments, for example, from one street you mentioned to another. Is that fair?
Yes.
Okay.
These are across town. They're not in the same neighborhood.
No, I understand. But for example, the assessor may differ on your opinion as to one neighborhood being superior to another may differ from the assessor's opinion. He may.
Yeah, but this has nothing to do with the assessor. This is vision. This is vision's class of neighborhoods.
But the assessor ultimately signs off on the
Yeah.
grand list and ultimately
Right.
reviews the revaluation. And when it comes to neighborhood codes and the determination as to, you know, how you classify certain neighborhoods, I would say, would you agree that generally assessors probably do have some input on that in their own town when doing a revaluation?
I would hope they would.
Okay, my experience, and by the way, my experience, they usually do.
Okay.
So
I
that's why
hope
I'm
so,
saying that.
but I just don't know how that they. that it-
Presume, I
yeah.
don't remember, presumably he did,
Yeah.
and again, he may disagree with you as to, you know, where locational adjustments should be made and to what extent they should be
Right.
made at all.
But that wasn't what the top of this said. It said detail by land neighborhood, by neighborhood. So neighborhoods are similar, usually couple streets, you know, you might have a neighborhood, 2, 3 streets.
Yes.
There's one neighborhood in Buckhorn, there's 10 streets, but it's all that neighborhood. That would be a neighborhood to me. This is one neighborhood on this side of town, one neighborhood on that side of town. But I don't know what Vision's in or outs are of this, but so then I asked about cap rates. Okay,
And can we pause for 2 minutes?
Yeah.
I've got to take a quick bathroom break.
Okay, sure.
Let's say 5 minutes. And while I do that, I gotta make one quick call. So I'm gonna put we're talking about some of the documents that are in this exhibit W. Would you like to continue?
yes. So I had just kind of questions or things that didn't make sense to me about like the cap rates, like they did a cap rate based on average on their adjustments, average, excellent, fair, good, poor, and T-bill for some of the stuff. And I just wanted to know how it was determined. Was it determined by location? There's a lot of properties that are, you know, like where was the parameters or whatever.
Is it fair to say that you had some questions about how the revaluation company derived its cap rates?
Yes,
Did you ever ask the assessor if he could explain that to you?
right. He did in the meeting, he said it was proprietary. That's the thing. Like I said, how are they because I had questions.
Oh, I understand, because, for example, let's assume that they relied upon information that was provided income and expense statements. If let's assume they relied on that information for purposes of determining the cap rate. Wouldn't that be proprietary information that they cannot share with you?
They should be able to tell like some of the formula, like I'm not asking for details, I'm just want like.
But I asked you a question just with regard to that issue. Let's assume that part of the proprietary information was income and expense forms, was based on information they derived from income and expense forms that property owners provided to the town of confidence. If that was the case, then would you agree that that information would not be discoverable by you and couldn't be shared?
I don't know. I don't have the answer to that. I'm not sure.
But let's just, okay, make expense statements taken filed by property owners. Are you aware of the fact that those income and expense statements under Connecticut law are required to be held in confidence by the assessor? Yeah. Are you aware that the assessor cannot share that information with other property owners and
Yes.
residents? Okay, so if you know that income and expense information is in fact confidential, and if the revaluation company relied upon confidential income and expense information in order to develop the capitalization rates, then in fact, wouldn't that be proprietary data? Look, just to finish the question, wouldn't that be proprietary data that they wouldn't be able to provide to you?
Yeah, possibly that if it was specific to a person's income and expense, but I wanted to know questions that were overall questions that shouldn't be a problem. I just don't think they wanted to answer it, honestly.
That I don't know, but it seems reasonable that there would be proprietary information that would have been
If it was
derived.
specific, yes.
That they could have derived
Right,
in order to
but
get the cap rates.
you're taking a bunch of income and expenses. You're not, you know, you're taking, it's a mass appraisal.
I'm not disagreeing with your larger point. I mean, I think that if what you're saying is that somebody could have said to you, you know, in general, cap rates, you know, on the post road, you know, I don't know if they're post road, but are, you know, in this area range from here to here and here to there and give you some general information.
Right.
That's changed. Did you ask for any general information from the assessor?
Well, yeah, well, we asked for some specific information.
I'm not talking about, but I'm not asking about specific. I'm saying, did you?
Well, like this is one of my exhibits.
What page?
LL 236, retail cap rate.
Okay.
Did not use the current year. they used the year before. So I want to know why. So in 2021,
I got it.
we're using
So did you-
2020.
Did you ask them?
Yes,
What would they say?
he said, first he said he didn't know. Then he said that they said that it was COVID and it was bad for retail, which made it even more suspect to me, because if it's not a good time period, we're in the time period that we're assessing. So if we have COVID and retail is doing awful, okay, that should be what is reflective of the retail industry.
But that's your opinion, right?
Yes, but
And then let me put it this way, could somebody who values property, someone who's qualified, have a difference of an opinion as to that issue with you?
anybody can have a difference of opinion.
No, but could somebody have a reasonable difference of opinion?
I don't know on that.
Well, let me ask it this way to you. Let's assume that
I just find it's interesting, because if I say no, you're gonna ask the question another way. It's almost, it's.
no,
just-
that's not it. No, I'm also. No,
Well, I know you're trying to understand, but I'm trying to explain that, you know, if you're in COVID and all the malls are closed, okay, and their rates are low or bad or whatever, because their industry is not doing well. It should be what the industry is in that time period, whether or not it was doing well or not doing well.
But I'm gonna ask you to follow, because maybe that's your opinion, and maybe if I ask you a couple of questions, maybe you may even change your opinion. So, all right, so you're familiar with vacancy rates?
Yes,
Okay, and so if my property has 50% vacancy, I own this strip plaza right
Yeah.
here. I have 50% vacancy at the time of the revaluation. Should my vacancy rate be 50%?
yes.
So you don't think that if somebody was gonna apply a vacancy rate to my property, they shouldn't apply a stabilized vacancy rate that may be lower?
Well, they could.
Let's assume that in the area where this property is located, vacancy rates for this type of property run around 10% at the time of value. Okay, and at the time of value, my property has an actual vacancy rate of 50%.
Right.
Would it be reasonable for somebody to use a vacancy rate of 10% versus 50, even though 50 is the actual?
No, they should use yours. If they're doing your appraisal, they should be using your vacancy rate. And they should then reconcile and say, the area is using this one. And I, as an appraiser, should be trying to find out why. What's the difference? Is it something external? Is it something internal? Is it something your management skill? You should be doing a little investigation on it.
When you're doing an ad valorem tax,
Well, for a mass appraisal, you're
Oh,
saying.
when you're valuing within an ad valorem assessment value, are you doing it on a fee simple or lease fee basis?
I don't know, I'm not doing it. You would have to tell me if it's if there's a lease person, then you would want to be doing the lease.
Have you ever provided an appraisal for purposes of a tax appeal?
Yes,
And when and so have you done it on more than one occasion?
yes.
Okay. And when you value, have you ever valued commercial property for tax appeal?
I think I have, yes.
And when you valued commercial property for the purpose of a tax appeal, for the purpose of an ad valorem tax appeal, did you value the fee simple or did you value it as a lease fee?
A fee simple.
And why is that?
Well, in this particular one, they weren't leasing the building out.
But in general, for an ad valorem tax appeal, are you valuing the fee simple or the lease fee?
It really will, it would, I can't answer that. I don't know.
I think the answer is you're valuing
Well,
I think you're valuing the fee simple in the ad valorem tax appeal. Could you tell me, do you know what the difference is between valuing the fee?
you have a lease fee, it's the lessor that they're leasing the property, so you're doing it for them. The fee simple is basically the more or less the owner, the whole property is a fee simple estate.
When you're doing a fee simple, are you trying to determine the market as if there weren't leases in place? While however, while taking into account both the market and the actuals.
Well, you would be aware of what the market was doing, but if you're doing a tax appeal, you're gonna be doing it for your client. So whatever the client is, that's who you're gonna be working for. You know, like on this one here, this one was one of them, and it's not one of yours, but you know, they did their effective gross income, their expenses, they did reserves for replacement. That was actually something that I hadn't seen on something. So I actually did a little bit of research on this one myself. And I try to figure it out with the reserves and without the reserves, just to see where that they fell. So, you know,
We make that LL 284.
I mean, I get the point. I mean, I understand. I understand what you're
Okay.
saying. I don't think we need it as an exhibit, but the example we were using, by the way, before I went to my vacancy example, we were talking about what you were questioning with. Just remind me, you were questioning
the year of the cap rate.
the year of the cap rate. And I guess the point I'm trying to make, not trying to make, the point I'm trying to address with you, okay, is that when you're valuing the fee simple, you want to be, do you want to be, when you're looking at income or you're looking at a vacancy, do you want to do so based on a stabilized basis? So for example, with vacancy, you want to look at it, what's a stabilized vacancy rate going to be, not what it's going to be just only on one period of time, correct?
Well, it depends.
Okay.
Like you're asking questions that are so, like, there could be so many different variables. It's hard.
I guess let me ask this then. When you have, with regard to the determination, so for the determination of appropriate market rents for retail,
Yeah.
it's your understanding that the revaluation company used 2020 data instead of 2021 data because of the COVID effect. Is that correct?
Yes.
And it sounds like, and you didn't agree with that decision, correct?
No, I'm not saying I didn't agree with it. I just wanted it explained.
Oh, okay, okay.
I wanted to know, you know, why they A, didn't do it, and B, would that have made a difference in these rates?
Well, that's fair. That's a fair question. That's fair to ask about. I mean,
Right.
I thought you were saying that it wouldn't be reasonable for them to have made that decision, whether you agree with it or not.
No,
Could
I
it
just
have been
wanted
a That's
I'm trying to look at their stuff
a
and,
fair question. Why? I mean, I'd want to know if I was working with them and I was the assessor, I would ask the question, why are you doing this?
right.
I think that's a fair point. And they wouldn't give you the
And
answer.
I also want to know on LL 244,
Well, hang on, before we go off this issue, did they ever respond to you as to why they used 2020 instead of 21 for,
all as I heard from Todd was they said COVID, because of COVID.
and
They didn't data.
did you want more information than that as to why they made the decision?
I was, I'm a little bit, the more I asked, the less I got. I just made all these little mental notes, and when people came in for appeals, I literally really looked at their data to see if it was different from this data. You know.
But with regard to this issue of what year they should have used for the retail rents, is it would it be total, would it be potential, would it be is it possible that it could be reasonable to have relied on the 20 income data versus 21 because they determined 21 to be a unique outlier because of the pandemic and that and because of the actual period of time that it would have this uniqueness of when COVID hit, and that 1 year happened to probably be an outlier. Is it possible that was a reasonable determination?
I don't know. I don't know what was in their head when they did it. I also don't know, like, lodging. That was another one I think that got hit pretty hard. And we did have some of the lodging appeals, and I can't really go into them because they appealed them to court. So, but they had some pretty compelling documents about the lodging industry, which obviously nobody was traveling. It was a pretty serious situation for them. And I don't know, I'm not saying what's right and wrong. I'm just trying to disseminate some of the information. That was just those questions. And then I did put on there the LL 247, the vision commercial appraiser thing, because I thought that was a really interesting, they were out looking for a commercial appraiser, but they aren't required for vision to have a license. But I don't know how you can say you're a commercial appraiser if you don't have a license. Very interesting. And then I brought into my next thing, the LL 248. It was my see something, say something comments to the town council. And basically, these pages are out of order. It was on the suppressant of the field cards for, I noticed that all of a sudden we had field cards from 2020, field cards from 2021. And then I went down to look up something for the town hall. And I noticed now on the back of field cards, effective year was suppressed of the field cards. Okay, they were gone. And so I was like, this is bizarre. They were there like a few days ago. And obviously I go down because I'm an appraiser and I use these cards in my daily life.
You know, I'm aware of what happened. I'm aware of the fact that from one year to another, they decided to suppress the effective year factor on the field card. So 1 year was on the field cards and the next year wasn't. And that the explanation I received, for whatever it's worth, was that the effective year is a calculation that's the result of the actual year built calculated by with the condition of the property, and that it's an after the fact kind of calculation, and whether so the value is done, and then after the fact you have an effective year that's created on the field card. So regardless of what it's not a factor in and of itself that determines value on the field card. And so my understanding is that some assessors in the state have an effective year built on their field cards and others don't.
We always had it. And until we started noticing these things we called it the fountain of youth, then it disappeared. Okay. But then in the Connecticut Association of Assessing Officers, Todd puts out a board member hotline. All members, all management is asking if I can find out how many towns suppress certain fields, such as effective year bill or effective area on their field cards. I just received the request that she is asking if I can get that number by the end of the day, Monday. Yes, this Monday. Okay. This Monday was going to be the council meeting that I was going to speak about. Okay. Please respond to helms@enfield.org. Thanks in advance. Todd Helms, Enfield. Lawrence Labrera. We suppressed both those in Windsor. Okay. Which I did know because in Windsor they've always been suppressed. Okay. Angel Johnson, and now she worked with Todd at Vision. I have several suppressed from the field cards to avoid confusion. Adjusted unit price in landlines, effective area, unit costs, and undepreciated values in the sub area, effective year bill in depreciation. Having done revaluations for a decade at Vision, may I add that turning these confusing and redundant calculation only fields to suppress on the card significantly simplifies the explanation of pricing with taxpayers. Many towns in Connecticut, Mass, and New Hampshire have these turned off on the cards during the revaluation hearing process and for the final print card. It would be less difficult to count the number of towns with these fields on, as they are very small. Angel. But that's not what I have found in my practice. Most of them are on. I find it a little bit hard to believe that these assessors are turning off the print fields for revaluation hearings and on the final print card, so people can't see them, but they're actually there. And I think that if you understand how that effective age from changing from an A to a B or a C or whatever, just changes the whole value of the back of the card. That's really what they are avoiding, trying to have the public see.
But it sounds like it's a permitted process to suppress it on the field, correct?
I don't believe it should be, if you have it, you're in the middle of hearings and you have people that are ready and could appeal, you're actually changing the back of the field card. So now you are going to represent that person, goes down to the town to get the card, and what was on their card in the hearing is now suppressed in the back. I didn't think that that should have been done without people knowing that their cards, they had information on there that now is gone.
Let me ask you this, as a BAA member, would it be helpful to you to have the effective year on the card when evaluating someone's property?
Yes, it is. It's useful because that's what they're saying the effective year of the property is.
I got it. So for your purposes as a BAA member, it would be helpful.
It would be helpful, but I think for anybody, for me as an appraiser, it's also helpful to see the back of these cards to know what, if the town had been in these properties or buy these properties, that they're supposed to be the eyes and the ears for us as a profession too. These cards are important cards.
But for purposes of whether or not to suppress certain information in the field card, is it fair to say that it's a decision that's within the purview of the assessor? You may not agree with the decision, but it's his decision.
I
It's
believe
his
that-
decision to
I
make.
believe the assessor and vision have are the only two capabilities of doing that.
But ultimately, it's the assessor's decision whether or not to suppress certain information on the field card that ultimately is part of the assessor's grand list that he signs off on annually, correct?
I'm assuming, I don't know if that is in his purview or not.
Okay.
That's why I brought it up.
Do you have anything else on?
Yeah,
on
well,
this one?
these were some of the depreciation tables for the
Obviously.
vision book.
Okay, so do you have concerns about any inconsistent depreciation schedules?
I don't know, I wouldn't use the word inconsistent. I would just use the word that,
Well, you're jumping around a little bit, I think.
Yeah.
Because I was gonna address this in my outline with you. So for example, you're jumping around a little, so I'll jump around in my outline then. Was there a report issued by the Enfield Board of Assessment Appeals that was dated May 28th, 2022?
I'd have to see it. Do you have it?
It was the report, if you remember, I do, but it was the report that
I'd like to read it to know.
sure.
I mean, there were a lot of reports.
no, it was a report that the BAA issued, was regarding decisions that you heard in April of 2022 and decided in May of 2022. I think Mr. Tyler authored it. And it was on behalf of the BAA. There you go. Take your time, just let me know when you had a chance to look at it. But I think there's issues that are addressed in that report that was issued by the BA that you're now hitting on at this time. So maybe easier for me to just go through my questions related to that report.
Okay, so there's minutes that are attached to this that were part of the special meeting as well. Would you want me to go through all the minutes too, or just to know, because there's two parts of this?
Yeah, I'll get to it in my questions. I mean, say that again,
So this report, then it went into minutes of the last, I think it was the last deliberations that we had. Special meeting, May 28th, 2022. That's all in here too.
yeah, I'm aware of that.
Oh, okay.
Okay, so you could keep the report in front of you if that's helpful. I have notes here about it. So why was this document drafted?
Well, I think we ran into so many problems during this particular reval that we just needed to get it in writing so that way. And I want to think that as things were going along, Tom was kind of keeping a tally of issues.
Mhm.
And, you know, as things were coming up, we would just, you know, mention this is this, or we've come up with this. And so that's really the reason for it, as far as I know.
Did Mr. Tyler author the document?
Yes, I believe he did.
Was it a collective statement of all three members of the BAA, even though he was the author of it?
Yes,
And so did you contribute to did you provide input and contribute to preparing the report?
yes, because we all, Donna, me, and Tom all were keeping little things and we were compiling the issues.
And that's consistent with what the others have told me. And did you agree with the conclusions contained in the report?
Yes,
One of the conclusions was that Vision's report was more than just a little flawed. Did you agree to that? Agree with that as well?
yes,
Did you reach out to anybody at Vision with respect to that conclusion?
no,
At some point, either before or after that report was issued, did you communicate your concerns to anyone at Vision?
no,
Are you aware that Vision has conducted the last three reevaluations in the town?
yes,
And do you remember, and I know you've been in town during those prior reevaluations, do you remember whether there were significant concerns raised during past reevaluations that Vision did?
well, I've only been on the board. I wasn't on the board at the prior revow. Because I've only been on the board for 5 years, maybe.
Okay.
So I only have it from the other perspective of bringing in tax appeals. So,
Well, then, but let me put it this way, during the prior reevaluation, you've been doing appraisal work since around 1999, correct?
yes,
And so that would cover, so the period of time during which Vision is done, let's say the last three reevaluations would go back, not even as far as that date. I mean, talking 15 years plus minus.
Yeah.
So during the time that the Vision has done the last three reevaluations, you've been in the appraisal business. Is that fair to say?
yes.
So during the prior three reevaluations, when you were in the appraisal business, did you ever raise major concerns for any prior reevaluations regarding Vision's work?
I don't remember. I do know I had concerns about some things, and I do know that I went in and spoke with the Vision appraiser, what I thought was a Vision appraiser for one client. And when I asked about, I said, well, I'm an appraiser, and the person out of their mouth was like, I'm an appraiser too. And I was like, oh, really? Where are you licensed? And then they were like, oh, we only have 15 minutes. If you don't get your 15 minutes here, then you're not going to get your time in, and they changed the subject. Now that I've kind of gone into the book, so to speak, I have really concerns that they were appraisers, to tell you the honest to God's truth. I don't know if they were just deflecting, and they would say that they're appraisers, but then when I was asking what license or state or whatever, I didn't get an answer. So I had concerns enough that I was bringing in appeals for things, but it was,
But beyond that, beyond your own appeals, did you
oh,
ever,
not even on my own properties, these could be clients.
but did you ever issue a letter to the town raising any concerns about Vision's work in general and the revaluation?
No, because I didn't notice, I didn't know of it.
In that report, there was a statement about inconsistent depreciation schedules, correct?
It says failure to provide consistent depreciation schedule.
Say that again.
It says failure, number 2,
Mhm.
failure to provide consistent depreciation schedules for residential and 2021 as well as for retail 2020 only.
So what did you mean by this?
Well, so Tom wrote it, but I think what I'm understanding it is that the way that they did their depreciation tables, it's age and effective age, but we don't really know how they came up with those. But their tables go from like good, poor, very good, and depending on where they go in on that line is how their values are assessed. So if somebody went from, and I use the example of 54 Hazard Avenue, because that one was the example I used, let's say at the town. If they were average, it would be one value. If they're good, it's another value. Okay, but with a click of a good to an average, it changes their value. So I believe that that's where the inconsistencies are. You know, if somebody didn't do any work at all in their property and they were average, and then the very next reval, they became good. What made them go from average to good? See, everybody was talking about numbers, but I was looking at the fact that their classes changed, you know, so I wanted to know, okay, during COVID, a lot of retailer and a lot of commercial properties did renovation work because people were in the stores or their buildings. So if I saw it go from average to good, I didn't see a building permit. So that was the other thing. So some people, most of the retail companies do take out building permits, so you would see on there. But I had actually been in this advanced auto because it's right down the street from me. So I never saw anything in the part of that the public is in, but I don't know that they didn't renovate the offices in the back. So they could have renovated something in the behind the scenes that I wasn't aware of. So when they came in, I just said, do you know if there was any renovations done for this particular building? And he said, no, I do not believe, but I will confirm it. And on that, I knew that they went from average to good. And that made a big financial difference based on these depreciation tables. Okay, so that's where I felt like there was not consistency.
Okay.
Okay. And I can show you like on the table, because these tables are very confusing. Like if you're not familiar with them, you see how these little lines down here to be, so they have these, and so on my sheets here, like on 252 and
I can see the
253.
numbers change.
Yeah.
I got it.
So the numbers changed like tremendously,
I got it.
you know.
With regard to on page 5 of that document, there was mention of the 3-page questionnaire that was mailed to appellants. Correct. Do you remember that there was a concern raised about that by the BA?
Yeah, was that the questionnaire that we didn't do, but that Todd was sending out? I have to look at it. There was.
I don't have the document right here in
All
front
right,
of me,
let me
but,
look. Let's see if I can find it.
but you know, I've
Was
seen
it about,
I've seen it before. There was a document that was sent out to the BAA appellants. Do you remember that?
yes.
And your BAA raised a concern about it. Can I see that for a second? That
Is it
document?
this, it's this one here. I think.
Yes.
Okay.
So that document, do you know if it was prepared by Todd?
I do not know.
Do you know whether the BAA has for previous years with the previous assessor mailed out a similar document to appellants requesting similar information?
No, I do not know that either.
If in fact you confirm that there was that type of questionnaire was similarly sent out by Della for many years, would that change your opinion as to whether whether Todd should have sent it out?
No,
Why?
because it should have been to the chairman. Like I've never been the chairperson, but Donna was a chairperson. Kelly Hemler was a chairperson prior to that. It would really depend on the chairperson because Todd was trying to change sheets in the beginning before Tom became the chairman. And he wanted us to use his appeal sheets, but we didn't. The board decided no, we did not want to change and use those appeal sheets. That was Donna's decision. Donna was the chairperson, and it might have been Kelly was before that. And so I would say it would depend on the chairperson as to who makes up the rules of what document gets sent out in our name. And it would have been discussed, I would have thought.
The
But I've
document,
only been on for 5 years, so I'm at a little bit of a disadvantage because I don't have like that. Like I think Donna's been on for 9.
you've been on for 5, right?
Yes.
So in the previous 4 years before, do you ever remember somebody asking you about
I've
whether
never
you should send
seen
that
this.
out? My understanding, by the way, is that document's been sent out for all 5 years and you're on the BA. And so that, let's assume that was the case. And I think based on Vicky Rose's testimony, her interview, it was my recollection. If that was the case, then if it was done for the 4 years before when you were on the BA, why would they have to ask you this time? I mean, shouldn't it have been done before as well? Shouldn't they have asked you before then as well?
Yeah, I think they should, yes.
So I know you raised some concerns about the assessor's resume, his credentials
Mhm.
earlier in this interview. Did you know him or have any interaction with him prior to him taking the position with Enfield? I only ask because you're an appraiser and
Yeah, I'm trying to think, like, I've been to Bloomfield, I don't know if I've had any, like, dealings with him. I don't know, I can't answer that.
okay. What are your thoughts about over the years have you dealt with Della Romont, who's a former
Yeah.
assessor? What were your thoughts about her in general?
Della, I thought she did a good job.
And Vicky Rose, what are your thoughts about her and as a deputy assessor working in the assessor's office over the years?
Vicky, I thought she did a good job, and like our BAA actually wrote a letter in support of her to become the assessor. We always had good interactions with her.
Okay. And do you mind if we take a break just for 1 minute?
Yeah,
Don't
fine.
mind. You know what? I'm just gonna let you keep going on. Deal with that later. Rather just keep rolling here. I think I'm done with that. So we'll take that back. With regard to the recording of hearings. I know that's something I've asked your colleagues on the BA about, so I think I understand what happened there. So I know what happened. I know there was an opinion issued by the town attorney about whether you can record the hearings. Regardless of the legality that you, quite frankly, you can. Did you have concerns about recording the hearings?
Not the fact that they were being recorded, but being recorded by the assessor himself.
All right, so is it fair to say your concern was that the assessor was in the room,
Yeah.
people, and was there, I think I know what your concern would be about the assessor being in the room, but you want to just tell me?
Yes, oh, well, because he was in the room, so I'm on this side, you are the applicant, correct?
If you want, I can do whatever
And
you
then
want.
Todd sits behind you, okay? So we're going through stuff, and I can see Todd,
Got it.
but he's making the gestures against the applicants. And, you were telling me, don't make the shaking the heads or whatever. He's shaking his head. He's making arm gestures. He's saying no. He's making these harassing kind of things, looking at papers, and so that was my LL 256.
If you had any,
When taping the BAA hearings, engaged in harassing conduct by interfering with the BAA by making faces, gestures, and shaking his head behind the applicant's backs. That's the problem that I had. He's in the room. He was kind of like, he couldn't help himself for doing it. Then, this is my little photo for you, okay?
okay,
When Tom Tyler leaves the room to go to the bathroom, Donna was doing
I see
her
the background,
paperwork.
please.
Yeah,
how to make this X. Exhibit X, so, I could see here, you put the tape recorder on the rack,
up in the coat rack,
up in the coat rack.
not being attended to, just stuck it up there, an extra one or whatever. I don't care about being taped. I'm taped at all kinds of things. I'm being taped here. Doesn't bother me at all. The part was that he he wanted us to tape it. You have to understand, he was trying to get us to tape the hearing. We did not want to be the ones taping the hearings. I don't want to be worried about a tape recorder. I don't want to have to categorize where it goes or what it is. But I frankly had a problem with the fact that the town attorney issued a legal opinion without ever talking to any of us. Never asked us anything about it. Just showed up. Here's the legal opinion.
Well, the legal opinion was with regard to whether it was legal to record, right?
Yeah, but the thing is Tom already had done something on the procedures of recording for the BAA hearings that we approved. And that's where was the thing. It's like we were saying, you must have your tape recorder in your possession. You can't just leave it sitting there, I mean, if the public wants to come in and tape something, have at it. I'm all for it. If they said, I want to tape this, I'd be like, go ahead.
But that's a recording. So what I want to ask you about is, so you mentioned Mr. Helms making hand gestures and trying to was he trying to signal to you
No,
information?
it was just disruptive.
But was he trying to signal to you as a BA member information about, was he trying to convey messaging to you by word?
Well, yes or no, or, mostly was no. So if somebody was talking and they were presenting something and he's shaking his head no, like he was like so you're telling me something, behind you is Todd and he's shaking his head no, and you don't know he's shaking his head no to all this stuff.
So did you think that was inappropriate?
Absolutely.
Did you think that was unprofessional?
Yes.
Do you think that it was unfair to the applicant?
Yes.
Do you think that he was trying to unduly influence your decision making?
Yes.
Did you at any point in time inform him that you thought his behavior during the hearings was inappropriate? Or did you or someone else on behalf of the BA do that?
No, Tom, it was a very stressful time, I have to say. Tom did address him several times about behaviors and things like that. It didn't matter. Todd ignored.
Well,
everything.
at some point you stopped attending the hearings, correct?
Yes, we thought that somebody must have told him, do not go there any longer. Because I think that the town was, people were complaining.
Okay.
I know myself, I was very uncomfortable just because honestly, I was starting to feel scared.
Do you believe that Mr. Helms created a confrontational atmosphere within the BAA hearings?
Yes,
And aside from making hand gestures or faces during the hearings, did he use any other intimidation tactics during the process?
no, not that I remember.
So you provided me with here a document that is the tax stabilization agreement in a summary, correct?
Yes,
Okay,
but
so when I go to that,
all right.
we can.
Is that numbered?
Yes, so
Yeah.
that's
That's what I
LL,
used to- yeah.
just the LL 257, and I'm gonna mark it as exhibit Y. And I'm familiar with the document. So, and I'm familiar with what happened. I reviewed the application statement, and I've asked others about this. I've asked
Okay.
town officials, staff, and I've asked some BA members about it. If you take a look at, so with regard to this agreement, the BAA, with regard to the properties that were the subject, there are 3 appeals, 307, 308, 309. Actually 4 and maybe
Yeah,
310,
10.
which,
Everybody forgets about 10.
okay, but those appeals were the ones that were, there was a question as to whether the tax agreement applied to those properties.
Yeah.
Okay. If you take a look at the tax stabilization agreement, which starts on page LL 261 or what you provided me.
Yeah.
Do you see that?
Mhm.
Please take a look at page LL 263, which is page 3 of the agreement.
Mhm.
And please read to yourself the definition of property. Let me know when you're done.
What was it that you wanted me to read?
Um,
The
well, why don't we do it this way? Let's read it together. Do you see where at the top of page LL 263?
Mhm.
All right, it says property.
Yeah.
Property means all real property that is owned by Nutmeg. See that part?
Yeah,
Okay. So far for the definition of property, it is with regard to property owned by Nutmeg, correct?
for that, yes.
And identified on Exhibit A as property subject to options to purchase.
Mhm.
Okay. Now, if you want to just read the rest of that paragraph and then let me know when you're done.
Okay.
Does this agreement apply to the property that is defined within the agreement as the property?
I don't know. I know what it says in here for property, and then there's maps. And
We'll get there, but
the way I look
Let's-
at it is property is property.
but let's look at this. The agreement says here. Look at section 3. Do you see that? Page
Yes.
LL 263.
Mhm.
Section 3B.
Yeah.
Could you read the first sentence just the first sentence for me?
During the abatement period, the town shall abate all town property taxes that, in the absence of this agreement, would be imposed against the property.
And so when the abatement here applies to the property, that means if we go back to the definition up top, all real property that's number 1 owned by Nutmeg and number 2 identified on Exhibit A as subject to the option to purchase, correct?
I'm an attorney. I almost feel like I can't answer that question without you having the previous history on it. So this property, this isn't the first time the property came in. This is the second time. The first time it came in, Tom wasn't on the board. This is the second time.
First time the property came in, the board denied the application. Is that correct? Application and upheld the assessor's taxing of the property, assessment of the property. Is that correct?
They wanted to come in and get PA 490. And we were told by Della that the tax stabilization agreement with the town, we couldn't change the agreement. So real estate was the real estate and the personal property. So that's how we got the tax stabilization agreement. So basically, on the properties that they came in for, we had to deny them the PA 490 because this tax stabilization agreement superseded the PA 490 stuff. That was done the year before. That's why I put that in there for you.
So for the year before,
April 22nd, 2021 minutes, and it was for the previous grand list.
but for the same properties the year before, the BAA denied the applications, correct?
The PA 490 applications.
They filed applications to the Board of Assessment Appeals, correct?
Yes.
So
PA 490.
whatever they filed their appeals for,
I know that they were filing for 490, and that's what we denied.
I'm saying, so in the BAA applications, they requested that the assessments be reduced, correct?
I don't remember what, I would have to have that. I would have to actually have their appeal. I don't have their appeal from the year before.
I have them, but it's not an important point.
But I
But I want,
kind of think it is an important point. I mean, because they were coming in to farm the property before the solar was completed. Della told us that we can't adjust a tax stabilization because that was an agreement outside of our purview. Like the council, it was outside of the BAA's.
let me ask you this way. Let me ask you this. If you don't mind. With regard to these applications, did the BAA grant the applications and essentially bring the property values down to zero, exempt them based on an understanding that the tax agreement applied to those properties?
We use the values of the stabilization agreement as the reason that they were locked into. But previous year, we denied them the PA 490 ability because the stabilization agreement superseded it.
Could you please take a look at page LL 281, the documents?
Yeah,
Could you please read? Well, first of all, is this page essentially the decision of the BA, an explanation as to what the BA did to decide these appeals?
yeah, this was the last day that he hand wrote these because we wanted him to look at that stabilization agreement.
And essentially, does this document provide that the BA determined that the solar agreement applies to the properties that were the subject of appeals 307 to 310?
Agreement dated February 3rd, 2020. By and between the town of Enfield and the Mountain Solar LLC, more specifically in accordance with the section 4 at page 4. Page 4. Real estate taxes on this property are due from Nutmeg Solar, not the appellant, and the town agreed. Can't read this word. Protected encompasses on the property to allow the tax assessor to levy the same tax on the same property twice cannot be tolerated.
So essentially, was the decision of the BAA to to apply this tax agreement to those properties?
Yes,
And we just talked about the definition of property, meaning or being defined as all real property that's owned by Nutmeg and identified on Exhibit A as subject to the option to purchase, correct?
I don't know, I would have to read. Let's see. Taxes considered real and personal property constructed by the town on the property shall represent the full property tax payment.
No, but you're reading a different section. Earlier you read the definition of property on page LL 263, correct?
Yes,
And the definition of property provides that that property is defined as property that's owned by Nutmeg and identified on Exhibit A as subject to the option to purchase, correct?
well, that's what it says up there, but then there's other areas that it talks about property.
But I'd like you to answer my question, which was, I'm asking about what,
Well, if you're saying that that paragraph, if that's what that paragraph is, that's what you're saying. I don't necessarily think that that's consistent throughout this document. I don't think the document was well written, but I don't know. I didn't write it. I don't even know who wrote it.
I'm asking the definition of property. Is it that it defines the property that's applicable in this agreement as owned by Nutmeg and number two, identified on Exhibit A as subject to the option to purchase?
Let's see what exhibit A is.
I'm asking you if that's what it says for the definition.
That's what it's saying.
Okay, so the properties that are, before we get to the Exhibit A, let's start with the first part. The properties that are the subject of appeals 307, 308, and 309. Are those properties owned by Nutmeg or owned by a different entity?
I'd have to look at the way it's written. I don't know, because it doesn't say here who owns what property.
But when I'm asking you, you have the appeals 307, 308, and 309, correct?
Are they in here?
Not, I could provide them to you. You heard those appeals. Were those appeals for property owned by the Jarmuck family or owned by Nutmeg?
Jarmuck, I believe, or well, I don't know if it was Jarmuck or an LLC. Jarmuck Farms LLC, here's one of them.
Okay, so those, the subject appeals we're talking about, 307, 308, and 309. I know you're mentioning 310, but other documents only reference 307, 308, and 309. Those properties were not owned by Nutmeg, correct?
I don't think so.
Okay. And the definition of property in the agreement that we've gone over now, I think ad nauseum, says that the property is property owned by Nutmeg, correct?
Yes.
Okay. And then the second part is that it is property that is shown on Exhibit A as being subject to the option to purchase, correct?
Yes.
So if we look at page LL 271, that's Exhibit A. And there's a section that says property subject to option to purchase. And then there's another, do you see what, could you go to that page, LL 271? You see
Yes.
that? All right. Do you see where it says so you see where it says property subject to ground leases?
Yes.
Does that appear to be the property that is the subject of appeals 307, 308, and 309?
I don't know. I'd have to know the option. So 102, 31, 102,
I'll make it. Yeah, if you take a look at the documents you provided me, if you look at, I can tell you I've already been over this, and let me just make this simpler for you. I can represent to you that the the properties that are subject to 307, 308, and 309 are described on Exhibit A as the properties that are subject to the ground lease.
Okay.
Assuming that, based on my representation, that that's correct. And I think I've been over it with one or both of your colleagues on the
Okay.
BAA as well, but assuming, just to expedite this, that's correct. Then if you're looking at this exhibit A, those three properties are they clearly not described as being subject to the option to purchase?
If that's what you're saying, yes, but you have to understand. We're in an appeal and we're doing this. We're not spending 10 hours reading this option. You know, we're only going off of the information that,
By the way, I get it, and I'll just tell you one thing. I don't understand why they didn't put the property subject to the option to purchase as exhibit A and put the properties that are subject to the ground lease as exhibit B. Is it my
honestly, I mean, we're reading this.
So I understand that it could be.
Right. But nevertheless,
Yes.
this is the way I look at it. The board made this decision based on the information that we read in these documents. And based on the fact that the year before, we actually denied, you know, like I knew that if it got denied and we had the tax stabilization agreement. So honestly, it was a decision the board made. And that's really the end. As far as that goes, you know, we reread it, we looked at it. I mean, this was one thing that we saved to the end. These last four.
But is it possible, now that I've showed you the definition of property, which is properties owned by Nutmeg,
Right.
not by Jarmark, and properties that are subject to the option to purchase, and not the ones that are actually the subject of the appeals that are in a different category on exhibit A. Is it possible, does it appear that maybe the BAA misapplied this agreement and in fact it does not apply for the properties that were the subject of appeals?
She had all these maps with it as well. And so when we were handed this document, the first time it was from Dell. So I just know that that's what we did. I don't know what would happen in the future. I just know that that's how I read it, Donna read it, Tom read it. We saved these four appeals to the end because we took kind of out of my wheelhouse because it was a very encompassing document and there was a lot to it. And I think we did the best that we could with it. And it wasn't exactly an easy write. All of I know is town manager Chris Bronson signed it. It was signed by the solar company. You know, if it didn't apply, then why was it given to us the year before? I don't know. I don't have those answers. Because I kind of look at it this way. If that's the case, then we would be wrong on this. So we wrongfully denied them PA 490 if that's the fact. On the prior year.
Okay, I see what you're saying. So what you're saying is that if you're not going to apply the tax stabilization agreement, if that was the wrong thing to do, then they should have been granted PA 490.
Yeah.
That's an interesting way. That's the first time somebody's raised that. Okay. Okay.
So. And I think we would have if we thought that would have been an option for them. But we were told by Della, we couldn't.
Okay.
So I guess.
Okay.
Two wrongs don't make a right, but.
I get it. So just a few more things I'd like to ask you about. I know we're trying
Sure.
to hopefully we'll get in today. or early evening. My understanding is that the BAA initially refused to turn over documents to the town, records regarding the BAA applications, but that eventually those documents were provided to the town. Is that correct?
Well, we always kept our documents and I was still, people, I always gave the town back their documents. Like if the town gave us the original appeals always went back. But Donna kept, I want to think she kept a lot of the records from the prior hearings. I know I still had some of mine, but I don't have a file of them. I found some from all of mine from 2019.
But did Donna keep those records at some point outside of town hall?
Yes,
Okay. And at some point, did the town request that all the records regarding the BA appeals be returned to town hall?
I don't know, but I believe that everything from the 2021 was, because I had those. I brought those down.
So how long have you been on the BA for?
I think 5 years, maybe. It's probably on the. Did it say when I went on the BA? I think it's.
I don't need exactly.
Not it wasn't like I never did the revalidation.
All right, so you were on the BA for 5 years. Did you serve on the BA at any time prior to that?
No,
Okay. Have you served in other positions with the town of Enfield?
yes.
And where?
I did work for the assessors department. I was hired as for my appraisal skills to go around and do all of the properties that came in for new permits, changes, or whatever they were behind. They asked me to do it. I asked Ella at the time, would it be a conflict for me if somebody came in for an appeal? And she said no, but that I should notify everybody that I went to their property that if they had a concern about me doing it, that I would recuse myself on the appeal level. And so you might see my name on some of the field cards because I'm listed as LL on some of the field cards. So if somebody came in for a new building permit, they needed to get their property measured. They needed to have something checked for an upgrade to see if they put in a new kitchen. I went out to hundreds and hundreds of properties. Took me a couple months. I had to take photos and then I brought everything back to the assessor's office.
And how long did you do that work for the town?
I think it was a 3-month contract that
Okay.
I had with them.
And so when did that take place?
Oh, I was on the BAA. Either Kelly or Donna was the chair. It has to be prior to COVID. Well, all right, I'll tell you now. Wait a minute. My grandson is 3.5. He was just a baby, probably 3 years ago. That's how I can remember. Because I remember him in the car. He was not very good in the car.
I know.
So I could not do. Some of them were just drive-by, what I call drive-by.
Yeah.
And I was like, oh, well, I could probably do it with Connor in the car,
I know how that is.
Yeah.
So, so you worked in the assessor's office for about 3-month period of time.
Yeah, it was just as a contractor.
What other, have you held other positions with the town?
I sat on for paid positions or?
No,
No, oh,
yeah,
okay.
anything.
I sat on the zoning board for years.
How many years?
Maybe.
That's a long time.
Yeah.
Been on the BA for 5 years. I don't want to forget to ask this. The BA members get paid.
Maybe.
That's a long time.
Yeah.
What has it been a stipend, like a one-time, like a lump sum, or has it been based on an hourly basis?
It's, I have not, I was not the chairperson. That was done through the chair, but I'm not sure. I don't know. I think I got a lump sum, but I don't remember. It was nominal. It wasn't a lot of money.
Going
In
back-
reval years, I think that they got more, but I don't know for that.
So you served on the P and Z commission for 8 years, is that
Yeah.
correct?
Yeah.
So I want to ask you just briefly about that, because I was aware that there's a case. There was a case with regard to a decision with you that was villages versus Enfield planning and zoning. Do you have a copy of this?
No.
Okay. So
Yeah, this,
I'll give you a copy.
I don't know. I don't know if this has to do with this.
So this is what I'll ask you just briefly, because on the BA, you're just serving.
Well, I think I've never seen it. I would like to read it.
Going up to read it?
Okay, yeah.
It sounds like she's saying she doesn't know what it has to do with anything, so I'd
Well-
like to read it.
You want to take a break for a moment? Do you want me to go off? I'm gonna pause. So I'm gonna put resume. So there was an application that was appeal number 352. I should have brought extra copies. This was an appeal that I do have an extra copy. That was filed by David and Lori Longhi.
Okay.
So my understanding is that with regard to this application, you did not participate in the BA hearing, is that correct?
Correct.
Did you have any discussions with either of the two BA members with regard to this application?
No,
Did you have any discussions with staff about the application? It was staff of the Board of Assessment Appeals.
like I think went in to get field cards or whatever.
Okay, I meant, once the application was filed, did you have a discussion with the assessor about it?
The assessor himself?
Yes.
No.
And so with regard to the hearing, again, my understanding is that, your husband, David Longhi was the one who attended, correct?
Yes.
So one question that came up when I was doing Mr. Tyler's interview was, with regard to the, my understanding, with regard to the deed of conveyance that may have resolved the title issue. So with regard to this application, my understanding was that, as of October 1, 2021, the applicant, provided information about there not being marketable title to the property as of that date. Is that correct?
Yes.
And that apparently there was some sort of issue with regard to the manner in which the deed was provided for the property.
Yes.
And so as a result of that, as of October 1, 2021, the property did not have marketable title.
Correct.
And that therefore it was the applicant's position that because it didn't have marketable title, it didn't have a value more than zero, correct?
Yes.
So at some point, did the issue of marketable title get resolved?
Yes.
So there was a quitclaim deed that was recorded on May 21, 2022. So I'll do that here. Well, here's the second page if you don't mind. So it looks like it was signed in April. You see the last page, it looks like it was signed on April. I think it was
April 3rd.
It was signed on April 3rd, 2022,
Mhm.
and it was recorded on. It was recorded on. Should have run another copy. Sorry. It was recorded on April 21st, 2022 at 10:09 a.m. Is that what it appears to say?
That's what it appears to say.
So my only question is, when the BA hearing took place, were you or was Mr. Longhi aware that you had obtained a deed that was executed, it looks like on April 3rd of 2022, that resolved the title issue?
I don't think we received this. We never, we never had anything to do with the clearing up of the title. The title company took care of it. So we never saw the documents, or the only thing that we were told was to come to the attorney to sign our part. Then they were going to, the title company was going to take care of everything else and do all the recordings. So we were out of it. I don't know when any of that happened.
Do you know when you signed, when you came in to sign something, do you know when that was?
I think it was in March, but I might have my. So this was the second go round with the title company. So I hired a first attorney. And I can read a little timeline. Might be helpful. So I had a contract to sell the property on 4/8/21. Okay. During that process, they were doing some title work and found out that I didn't actually own the property. So that was the first time I found out that I didn't own the property that I was selling. So that was on April 21st, 21. Then on May 13th, I was trying to find an attorney. So I got names of a couple attorneys, called an attorney that's very widely known in the area. And he took the case on May 13th of 2021, was working with the town attorney in Enfield, couldn't get anything with him. And in December of that year, so May, June, July, August, September, October, November, December, 8 months he has it. He says he can't fix the title and that I'd have to get an attorney that could do an action of quiet title. So then I hired another attorney on December 28th of 21. And that was Despina Chartinis. And she basically had us, so she was working with the title company because I guess at the time the courts weren't open, so it was going to take a long time to do the action of quiet title. And so she finally reached the person that I had. So the town sold me this lot. The town of Enfield sold me this lot. I didn't actually own the lot, pay taxes on the lot for 5 years.
Okay.
Find out that now I have a contract to sell the lot. Can't sell the lot till the title gets straightened out. Hired one attorney, couldn't do it. Hired the second attorney. She finally got it to the point where she was working with Caddick. And the Caddick attorney did everything. We never did anything other than go into her office and sign paperwork. And she said, we need to have you sign this paperwork early so that we can get the other party to sign their stuff. And then they were supposed to do some affidavits to try to
Resolve
resolve
it.
it.
So is it fair to say that as of, to the best of your recollection, as of the date that the appeal was considered, was heard,
We did not know it got fixed.
so you didn't know it was resolved, and your husband wouldn't have known
Right.
either. So at some point after it was recorded, someone from Caddick would have at some later time provided you a notice.
Well, no, I think that they provided it to Despina. They
Then-
sent
okay.
stuff to Despina, and then Despina sent the stuff to us at some point.
And actually, I said the wrong date there. The hearing took place, I think, on April 20th. The document was recorded on the 21st, but is it fair to say that based on your testimony that on April 20th, you wouldn't have known that it was resolved? You only would have found out that it was resolved after Caddick filed it then after Caddick sent it to, and Caddick is a title company.
Yeah.
But after Caddick sent it to your attorney,
Yeah.
and then after your attorney sent it to you.
Yeah.
So some period of time after the hearing, you found out.
Yeah.
And so your husband didn't know either when he went to
No.
it. Okay. That's all I have. On this.
Yeah, this was like
Oh,
a,
I have one more question on this.
okay,
So, even if the title issue was resolved at the time of the hearing,
Mhm.
do you think it should matter if, as of October 1 of 2021, there was no marketable title?
because October 1 of 2021 is all appeals. That's what the appeals are based on, that they,
Understood.
Yeah.
So do you think that
if
it
I,
shouldn't matter as of what it was, it shouldn't matter whether the title issue was resolved in April or May of 2022, because as of October 1, the date of value on October 1, 2021, it wasn't resolved.
right, it wasn't resolved.
And then if it got resolved at some later date, do you believe the proper thing to do would be for the town then to address, to then value it accordingly on the October 1, 2022 brand list?
Yes,
I don't have anything further, but I would like to ask you, is there anything further that you would like to tell me? And I'll ask the question with also giving you this caveat. If there's something else you want to add in the next week,
okay,
let me know.
okay,
If there's something else, you could send it to me directly. You could do it through your counsel.
okay.
So I want to give an opportunity if there's anything else you want to share with me, but if you think of something afterwards, you can provide it to me.
Okay. So I guess I had two kind of questions. One of them we touched on is I wanted to know if other farms that were removed from PA 490 or values changed on PA 490 farms that didn't appeal. Like there was way more farms in Enfield. So if like you're doing this investigation or review or whatever, are you looking at only the appeals or are you looking at all the values?
I'm not looking at every appeal. I think what we're going to do is, one issue is, I think, we have to look at is it proper for him, he had a pattern of changing classifications, land classifications for the farmland.
Mhm.
And was the manner in which he did it overall, or in general, was it proper? One issue that you raised aptly was where the actual use, where he determined that there was a higher and better use, which differed from the actual use, and that resulted in his decision to increase the classification. Is that correct?
Right.
So I don't think we're going to get into every single
Right.
property. I mean, there's the general things he did.
But the other component of that is that the classes are one thing, but the overall assessment value that these people would be paying if it dropped out of PA 490 or on or estate stuff doubled, tripled, quadrupled. And those values were the values that concerned me because,
I don't know if we're going to get it. To answer your question, I don't know if we're going to get into that because there's only so much I could do. Like, for example,
but this is like an important thing on value of properties in Enfield. So you're taking like and let me
Yeah,
turn it
sure.
around and
Yeah,
do it to you.
sure,
So your house in, I don't know where you live, let's say
orange.
Orange. Okay. So your house in Orange, your value is $600,000.
Yes.
And so then all of a sudden that value goes from 600 to 900 to $1.2 million. So now that to me is the concern of values that you would be concerned about it. That's why I'm concerned about the values of your farmland.
I wouldn't be, to be frank with you, because first of all, my value house probably is around that, or and I think my value in the last reval was lower. Probably was in, I don't know, mid-4s or I don't know what it was.
So if it doubled or tripled, you wouldn't be concerned about it.
I mean, I think that if a portion of my property, if the excess land value doubled or tripled, I don't know if I would raise a little red flag for me. what's the true and actual value as of the date? So if my property gets valued and our reval is coming up, I think this October, if my property gets valued for 650,000, and I think my property is probably worth around 6, whether a portion of that valuation went up, doubled or tripled, it's really irrelevant, because if it's worth, if that's about what the right value is, it doesn't matter how the assessor got there. I mean, it doesn't matter how it was, and the law is pretty clear on that too. It matters what the actual value is, not how it's been broken out. But I understand the point you're making. I would just say that there's only so much we could do in this review.
But this is on PA 490 properties. That's the point that I'm trying to make, is that the PA 490 values were targeted, or I feel that they could have been targeted. And the reason why that those were a target, and this is just my opinion, okay, just totally my opinion. PA 490 values can get inflated, and the average taxpayer is not going to be complaining about it because they don't know about it, because they're paying off of a use value and not off of that assessed value.
Understand.
So a lot of times it gets slipped by. But in this case, they went skyrocketing. And things doubled, like a landlocked piece doubled, there was imputed lot values. So that is what is making these bigger values. And that's why it was a concern.
Yeah, it's hard to say what we're going to do or not do in the report, but I'll just say that there are certain issues, trends, and what the assessor did with regard to farmland that we're going to look at,
Okay.
including the way he treated woodland. And, if something isn't, if something was a separate parcelable part of the farm unit, and how we treated that differently than like the former assessor. Having said that, even for example, we're supposed to be looking at what the BAA did, and I'm not going to look at every BAA decision or every BAA application, because at the end of the day, whether we agree with it or not is irrelevant. Like the BAA has authority, and it doesn't matter what I think. It doesn't matter what, frankly, town officials think. You're a separate body. There's some applications that I think came to our attention where it's a question like, how could you legally even get to that value? For example, like the JARMOC, the tax stabilization agreement, that's one that, either it's right or wrong, but it's not the decision could be wrong because it was a misapplication of an agreement, possibly. I'm just saying, whereas whether you decided to lower someone's value, I may not agree with it, but it's none of my, it's not my place to say to opine on it.
Mhm.
And so I think that, and to some degree, it's the same thing with the assessor's work. I may disagree with certain values of the assessor or the reval company, or you may disagree how they came up with those.
But my thing was the MOU.
But it doesn't mean that it's part of.
So the memorandum of understanding, they were looking for these answers. So that's why I was wondering how you were.
Yeah, no, I've communicated with council liaisons on the MOU issues, and some of them probably were awkwardly crafted. I mean, I think they tried their best, and we've talked about those issues in our confidential discussions we've had, and they've recognized that some of the questions maybe didn't exactly make perfect sense, and some of them maybe can't be answered, and most of them will be, but some of them have to be kind of revised. So we, that was to guide me, because I asked for some guidance, but you were asked overall to review the whole reval process, from the reval company to the assessor's work, the BA's work, and that's what we're doing. And the MOU, those questions were guidance, but we're asked to do an investigation. So at the end of the day, we have to determine what we think is relevant to look at. The overall investigation is look at what was done in the revaluation.
Mhm.
Here's some questions that are helpful to you to look at, and we're going to try to address as much. It gives us flavor for what people want us to address. But at the end of the day, it's my investigation. At the end of the day, I'll make determinations as to what issues I think are relevant and which aren't.
Okay, so that brings me to my next question then.
Okay.
So you asked me to bring in snippets, kind of like consolidate down, which I did. I tried to.
You did a great
focus
job.
on-
You did a perfect job. That's
on
great.
the issues, certain issues. So I wanted to give you the backup document. But with this, we saw over and over and over. So I just want you to understand that it wasn't like I'm showing you one document and it's only one parcel. I'm showing you one document and it could be 10 parcels. And so it was, it would have been a concern if it was one parcel, honestly. I would think it was off the spectrum, but when we saw it over multiple properties and multiple things, and that's just what we were seeing, that's why I think it was such a concern. And then.
And by the way, I'm aware of that, and I
Okay.
appreciate the fact that you cherry picked what you determined to be the quote unquote most egregious examples. And but they're examples of a pattern is what you're
Yeah.
telling me, and so I appreciate that, I understand that.
And then I thought, like, the other part of it is to kind of test like the vision stuff, because I'm not convinced that all of that was totally, I don't want to say the word proper, but there was a lot of little issues with the vision report. Holes, I should say, holes here and holes there. So I know that vision is supposed to do like a sales ratio test on properties. I didn't know if you were doing an independent sales ratio test on these properties to show if there was any disparaging amounts in value.
No, I wouldn't be qualified to do that. And I did confirm though that they provided that those tests were done with OPM and they passed them and there's no concerns raised by OPM.
That vision did themselves, correct?
Yes, there's
okay.
there's certain things that you have to do with OPM in order to get compliant, in order to get sign off on the revaluation. That was all done. There were no issues.
Those you gave me.
Okay, so, bottom line is, that's just beyond our bailiwick. So, yeah, I mean, whether they did a good job with the revaluation is something that town could appoint a committee if it wanted to, the next time they do a revaluation, try to do an RFP for a reval company. Take into consideration analysis of what Vision did in this last revaluation, if people have concerns about it, but we're looking for any major issues, and the fact that they passed everything with OPM is probably as far as we go into those specific issues, as to whether the reval was pass muster in that regard.
Mhm.
If you don't have anything further at this time, like I said, if you have something later you want to
Nope,
share with us, you
I think
can.
I'm good right now.
I'm going to stop the recording, but I do want to find